For what?
For inclusion, my lord, inclusion.
Inclusion, no 34 right now. Wait.
My lord,
May I have you need to mention two execution matters for withdrawal?
my lord, may we permit to mention, my lord, applications under section 29A, my lord, for extension of the mandate, my lord.
Why you have to mention it?
Yes.
Why do you have to mention it?
Why this is not running in the list, my lord, for inclusion in the list.
May I be permitted to mention, madam, I have mentioned this matter previously also, madam. This matter has been settled between the parties. Arbitral tribunal has already ready to publish the award. Only thing left is in a section 9 matter, and order was passed by this honorable court to deposit some money with the registered original side. That has to be released. An order for release of the
application.
I've taken out an application. That application has to be listed, but the mother file is not available herein. That is why the department is not giving it for listing. And I'm saying only the GA is sufficient for taking up the matter.
Where's the mother file?
That has gone to the department, Kizipur department, I think. This is the last minutes that has been given. The mandate is expiring of the arbitral tribunal on 5th of February. That is why I'm paying for listing, my lord. Because I have to again take out a section 29A and that.
My lord, may I be permitted to mention one
Develop.
matter? My lord, may I be permitted to mention one matter, your lordship? I am only seeking for correction of some error in the order. Your lordship.
Keep it in to be mentioned.
May I please mention a matter also for inclusion of section
To
34.
be mentioned. Gan.
Section 34. Section 34.
Not right now 34.
Okay.
Award is of which year?
Your award is of 2023, your lordship.
Actually, may I
Lordship,
permit
this
it
matter.
Wait.
May I permit it to mention a matter for withdrawal, lordship? Execution matter. The agreement has been settlement has been done.
Good morning, my lord. Sir, I'm here to mention a matter for the expeditious disposal
Of
inland waterways of
what
authorized.
is it? 34. What is the petition?
Sir, CPAN 20 of 2026.
CPA?
Yes, sir. The case number is WPA 30900 of 2024.
WPA. Why WPA is being mentioned here, sir?
Appeal,
But
sir.
it's a contempt. What
Yes,
is
sir.
it?
Yes, sir. Contempt, sir.
You're filing a contempt.
No, sir. It is already filed.
Then what do you want?
Sir, for the near hearing, sir.
No urgency.
Yeah, my lords, kindly to mention an execution case, your lordship. The matter had appeared before, and on the last occasion, my lord had directed to file affidavits. Affidavits have been filed. 90% of the awarded sum has been received. Only in regards to the interest part, under the award, we are entitled to a little more interest. So, your lordship may kindly.
Nothing doing. Not right now.
Lordship,
Enjoy your 90%. Let it come in the due course.
lordship, it won't
No,
take
madam,
much
these
time, your
interest
lordship.
things I
Kindly.
parties never settle on the
Interest
interest.
part, your lordship, under the award.
Sorry. Yes.
This has come at my instance, my lord. But there was an original order of 2018 where we were supposed to put in a bank guarantee, on lieu of which we got a stay, my lord. The bank guarantee had expired. And we had taken out the bank guarantee for extension, but it was a bit out of time. The registry is not accepting it. I've got the original bank guarantee. It is valid till 2027. If your lordship would be kindly pleased to extend the
Should have
time.
moved an application.
And if your lordship pleases, I will do that.
Move an application.
I'll do that. So,
Mistake on learned counsel for the petitioner. Seeks and is granted 1 week time to file an appropriate application
we'll do that.
in accordance with law.
Very grateful, my lord. Move for that, please.
I'll give a date, then in the monthly list, I'll put it whenever the application is there. You mention it, we'll keep it.
I'll do that, my lord.
All right.
But if the original AP could be listed, my lord, in the monthly list, then that would be.
Keep it in the
Because it's an
monthly list of
old award,
March.
my lord, so if we could also get it heard out.
To be listed in the monthly list of March.
That was the listing of the book. Very grateful, my lord.
Lordship, I am appearing for the award holder, lordship. Lordship, there is a minor critical error in this file, lordship. For the reason we intend to withdraw the application for with liberty to file a fresh, lordship.
For the judgment.
Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law.
Yes, Your Lordship.
Your Lordship, this has come at our behest, Your Lordship. Your Lordship, we are withdrawing the Section 34 application. There was an order on 26 March 2025. There was a stay with regard to an observation of the learned tribunal, arbitral tribunal, and there was a direction to deposit 5,68,000.
Okay.
26 March 2025. Copy.
26 March order, right?
26th March, Your Lordship. Your Lordship, at page 2.
So what is there in Masiram in this?
Your Lordship, there was an observation. So we had challenged the interim award that was passed, and there was a stay granted subject to pay deposit of 5,68,000. Your Lordship, we had deposited. Now the arbitration is almost coming to an end.
Consider this minutes, it will be clear. I highlighted the portion.
At page 3 of the minutes.
Yes.
Your Lordship, there is the minutes of the meeting in which Your Lordship will see page 3, para B, last para. We have agreed to withdraw the application in view of the submission on behalf of the counsel for the claimant.
Yes.
Your Lordship, in view of this, we are withdrawing this application and they are giving consent to withdrawal of the amounts. Your Lordship, may kindly record this paragraph.
Take down. Learned counsel for the petitioner
Right.
seeks to withdraw the present petition. Full stop. The parties have arrived at a understanding that the petitioner will withdraw the application, that the petitioner will withdraw the petition, and the amount which has been deposited with this court of rupees 5,68,426. 5,68,426 will be shared between the petitioner and the respondent in the ratio of 30% and 70%. At the time when the final accounting of the partnership firm will be made. Full stop. Learned counsel for the respondent states that the said understanding has been recorded before the Honorable Sole Arbitrator
Lordship,
Three arbitral
before the arbitral tribunal in its order dated 17/5/2025. Full stop. A copy of the said order is handed over and the same is taken on record. Full stop. In view of the said understanding, the present petition is dismissed as withdrawn
Very well.
Liberty to withdraw them.
And with liberty to my lord, withdraw the
with
security.
liberty to the petitioner to withdraw said amount, the amount of rupees 5,58,426
Register originals.
lying with the registrar original site of this court.
Grateful, my lord. My apologies of not being able to be there. This was called my lord.
Sridhar was here.
Yes, he was there. Great.
Later.
Your Honor, I'm on behalf of the judgment letter, Your Honor. Within time frame, we could not able to file the affidavit of asset, Your Honor. My lord, so kindly give a leave to file the affidavit of asset.
Your Lordship, I am for the award holder.
In the meantime, we have started making payment also.
All right. Learned counsel for the judgment debtor. Seeks and is granted further time of 2 weeks.
My affidavit is ready, Your Honor. My Honor is
1
ready.
week.
Yes, 1 week.
1 week to file his affidavit of asset.
Your Lordship, his affidavit and assets is ready.
It's ready.
It's ready.
He wants to
Coming
file it.
submit the affidavit and assets.
So let him file in the
Within
registry
the course of 1 week,
with the during the course of the day. Seeks and is granted liberty to file the affidavit of asset during the course of the day. Let this matter be listed after examination. Let this matter be listed for examination of the judgment debtor number
2.
Number 2 on give after 2-3 weeks.
Sir, बोलिए affidavit of assets जमा
26th, all execution matters are 26th of February. 26th February.
Okay. So give us.
উনি কিন্তু পেমেন্ট স্টার্ট করেছে
এটা?
পেমেন্ট স্টার্ট করেছে
I to accept it.
আচ্ছা
Lord, item 5, my lord, I am appearing for the petitioner, my lord. My application under section 9, my lord, from what I find from the affidavit of service, respondents number 2, 3, and 4, the service is not complete. We were
The
granted,
petitioner seeks and is granted further time of.
my lord, kindly gives me a week, because what we are, my lord, also seeing is that they are deliberately avoiding service. My lord, in that case, my lord, I'll try and persuade your lordships for, my lord, to canvass the point of deemed service. With the same address, they have received previous communications, letters, the loan recall notice, but so far as the petition is concerned, my lord, they are avoiding the service. I'll demonstrate that.
Do a publication.
Lord?
Do a publication and come back.
But I'll persuade your lordships. Your lordships may consider, my lord, because they have received same address. They have received, my lord, multiple correspondence. Only thing they are avoiding is the present application under section 9. My lord, case of loan taken and default committed.
What is the amount?
My lord, the amount is, my lord, more than 5 crores. My lord.
It's a big company. Seeks and is granted. 1 week, 2 weeks. 2 weeks.
My lord, we
time
kindly
effect
grant
is
it
upon
to,
the-
my lord, 10 days.
upon the
My lord, within.
respondent. List after 3 weeks.
Sir, may I just pray for, my lord, after 2 weeks, my lord? Any date after 2 weeks.
24th February.
24th. Grateful.
24th.
What you can. Question 21st. Yes.
Yes, Mr. Banji.
Yes, my lord, this is an interim order that your lordship had granted on my section 9. We mentioned the matter on the 19th because it was to expire on 21st. Item number 6.
What happened to the constitution of the arbitral tribunal?
That's pending, my lord. My section 11 application.
Why is it pending? Why you're not mentioning it, getting it listed?
No,
It's supposed to be made returnable on 29.
একবার হয়েছে না?
একবার হয়েছে, it has been made returnable on 29.
It was taken up once. You know, the other side was in some difficulty. They wanted to keep it on the 29th. So it's been kept on the 29th now
February.
of
This
January.
month, this month.
Of
okay.
January.
Lordship, no question for extension, nothing.
Sorry?
Lordship, regarding legal.
No objection for extension.
Lordship has directed me to file affidavit. In this regard, your Lordship, allow me some more time to file.
Learned counsel for the petitioner. Learned counsel for the respondent seeks and is granted.
Filing ছিল affidavit.
Further,
There was no direction for filing affidavits here, my lord. Your Lordship had granted us the order and then it was kept pending because we were to take steps under 11. Kindly have a look at the 20. Oh, yes, my lord, it's there. I'm sorry. 26 November.
First line is there.
My mistake. 26 November, first line, it's there.
learned counsel for the respondent seeks and is granted further time off.
4 weeks. 4 weeks. 4 weeks.
Again, 4 weeks. Constitute the arbitral tribunal. Why
It is
should
the
this
day. I'm hoping the day it will get
further
called
time of
again.
2 weeks, 2 weeks, 3 weeks, 3 weeks to file his affidavit in opposition. First. Interim order granted earlier is extended further for a period of 4 weeks.
Lord, could it be till disposal of the application? Because they're anyways taking 3 weeks time to file the affidavit.
I'll
By
give
then,
them 2
hopefully-
weeks. 2 weeks. I'll give them 2 weeks.
2 weeks and then us 1 week, yes, my lord.
2 weeks. Let this matter be listed on 23rd of February. 23rd of February. Interim order is extended further for a period of 4 weeks. 4 weeks. Learned counsel for the petitioner states that the section 11(6) application is listed for hearing on 29th of January. Full stop. List after
Lordship, when the extension 4 weeks, then your Lordship 3 weeks.
3 weeks. Affidavit 3 weeks.
Great.
My lord, this is my 29A application for the extension of the mandate of the arbitrator.
My lord, in this matter, I am appearing on behalf of respondent, my lord. I received my brief today, my lord.
Sorry.
I received my brief today, my lord. So I'm praying 1 week time, my lord.
29, do you have objection?
My lord, I need to talk to railway. So my lord, I need 1 week
A
accommodation.
week is too long to take instruction, madam. Come back day after.
My lord, then Thursday.
Thursday is what do we have? Day after tomorrow.
Day after tomorrow, Thursday.
Execution day is day after tomorrow. Then keep it on Friday in the early
Friday. Grateful, my lord.
Not.
My lord, may I file the affidavit of service? Friday. Grateful.
Grateful.
My section 29A application, my lord. It's the first section 29A application. The tribunal.
Any objection? Give me the dates.
You know, the tribunal
was
was
the-
constituted on 7th of February 2024.
The High Court order is 7th February.
7th February 2024. My lord, the pleadings were complete on 13th of June 2024. Thereafter, my lord, the voluntary consent by the parties, my lord, was given under section 29A3 on 22nd April 2025. And my lord, finally, the 1.5 year period expired, my lord, on 18th of it expired on 12th of December 2025. Prior to that, on 18th of November, tribunal directed the parties to seek an extension from this court.
Take down the petitioner has preferred the present application under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of the mandate of the arbitral tribunal for conducting the proceedings and publication of the award. Full stop. Learned counsel for the petitioner submits that this court-wide order dated 7/2/2024 had appointed the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. With the consent of the parties, the mandate of the arbitral tribunal was extended for a period of 6 months till 12/6/2025. Full stop. He further states that several hearings, how many hearings?
24 sittings have been, my lord.
He further states that 24
The
sittings have been
mandate was
held by the
extended till 12th of December, my lord.
arbitral tribunal. Full stop. What is the stage of the
Lord, the submissions on behalf of the claimants have been concluded. After conclusion of submissions, my lord, an application for recalling of a witness of respondent has been filed, my
The
lord.
only thing that has to be taken care of, my lord, the application has been filed on 12th of January. The mandate had expired in
That doesn't
December.
matter.
Yes, ma'am. That is what I was wanting to indicate, madam.
That doesn't matter. He further states that the tribunal concluded the evidence of the parties and that the claimant concluded its argument and the matter had been fixed for respondents.
But an application has been filed on behalf of the respondent for recalling of its evidence.
However, at this stage, the respondent moved an application for leading additional evidence.
Yes, ma'am. Or recalling of all of my witnesses.
Full stop. He further states that the tribunal is hearing the argument on this application. Full stop. In view of this, petitioner is seeking extension of 6 months. 6 months for concluding the arbitral proceedings and publication of the award. Full stop. 8 months. How much? What have you asked?
If it commences, if it can be 8
Learned
months.
counsel for the asked for 6 months. Learned counsel for the respondent states that he has no objection to the present application. Full stop. Upon consideration of the materials placed on record, this court is satisfied that no delay is attributable to the learned sole arbitrator in conducting the proceedings. Full stop. Having regard to the advanced stage of the arbitration and in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of 6 months from today. Full stop. Learned sole arbitrator is requested to make all reasonable endeavors to conclude the proceedings and publish the award within the extended time period. Full stop. With the aforesaid direction, the present petition stands disposed of.
Grateful, my lord.
Obligation.
My lord, in this matter, I appear for.
Mr. Pushan Majumdar is the advocate on record for the petitioner. Just been informed by his clerk that due to some personal difficulty could not appear today. Lordship kindly makes it not today.
My lord, let me just submit one thing. So this is a 29A application, my lord. My liquidation application has been allowed in NCLT and it is reserved for orders. So my lord, if my lord may please, he may extend it, but otherwise the no purpose would be served. Otherwise the liquidator will be appointed in any event.
Let him come. Lawyer is not there. Not today.
Grateful.
Your Lordship, I am on behalf of the petitioner. Today is fixed for filing a report of receiver. My Lord, we have received a verbal instruction from the client. The matter may get amicably resolved. Nevertheless, kindly give us a last opportunity to gather a written objection from the client, the withdraw and not place the matter.
Not today. When do you want?
Kindly give 2 weeks.
Monday?
Monday, yes, sir.
Monday?
Okay, sir.
Not today. Keep it for Monday. Get the instruction. Is mobile Monday?
That 11.
No, 10.
11, my lord.
Yes.
This matter, my lord, I have been appointed by your lordship as a special officer, my lord. My lord, we have inspected the premises in the Haridwar on 20th and 21st, and in the 22nd evening I came back. My lord, I'm praying for some time to prepare the report, my lord.
Learned counsel for the receiver, the receiver. Seeks and is granted. Ms. Bhowal, the receiver who has been appointed in the present matter, seeks and is granted. How much time?
My lord, next Tuesday, my lord.
1 week time to file it. She states that she has conducted the proceedings. She seeks and is granted 1 week time to file her report. Let this matter be listed after. Sixth? 6th February?
6. My lord, I'm grateful to your lordship, my lord.
We responded.
Where's the petitioner? He's not here?
Shall I?
I'm for the respondent.
मतलब उसमें लिख लेना none for the petitioner.
Lordship, this matter has been settled between the parties.
Learned counsel for the petitioner states that the matter has been amicably settled between the parties. She seeks to withdraw the present petition. The same is dismissed as withdrawn. Any instruction?
Lordship, it's not handy with me right now.
My section 9 application, my lord. I file my reply, my lord, to the affidavit in opposition, my lord, which has been filed by them. I'm seeking for an interim order, my lord. I have given an advance copy to them, my lord, so that there is no problem. As far as, my lord, 4 to 6 are concerned, my lord, I am not using a reply for the simple reason that they have given, my lord, enclosed order of the Supreme Court, wherein, my lord, then stay has been obtained in respect of a judgment which has been passed by the, my lord, honorable court taking up suit matters, my lord. So that issue is pending, so I can't seek any reliefs against 426, and I should not use a reply also, because, my lord, that might, my lord, be enclosed before the Supreme Court saying that I'm taking a different stand. So as far as they are concerned, my lord, I'm not making any prayers today, my lord, since the SLP is pending. And my main prayer is with regard to, my lord, 1 to, my lord, 1 to 3. So, my lord, I'll proceed against them. I filed a reply to.
Yeah, for the respondent was 4 to 6. That submission could be recorded only, and we won't have to make any submissions. If they are not seeking any prayers against us.
In view of the SLP being pending, I can't, my lord. That's a sub judice matter.
Learned counsel of the petitioner states that at the outset, learned counsel for the petitioner states that he is not seeking any relief against respondent number 4 to 6. Full stop. He further states that the dispute between the parties are pending adjudication before the Honorable Supreme Court in SLP number
35407 of 2025.
35407 of 2025. 2025. Full stop.
Page gulo bolo. Grateful, my lord. Now, my lord, this, my lord, agreement between the parties, whereby, my lord, I have advanced, my lord, amounts to them, arises out of a facility agreement, my lord, in which, my lord, invoices given by, my lord, vendors who are connected in the business with them would be paid by me. My lord, in return, they would pay, my lord, my amount, and, my lord, they would take the services from the vendor. And that is, my lord, the arrangement which is there, my lord, between the parties. If your lordship kindly takes, my lord, page 23 is the facility agreement, my lord. And your lordship kindly comes to, my lord,
And who are these respondent number 4, 5, 6? How are they connected to
my
this?
lord, they are the signatories and guarantors, my lord, to the agreement. They say they had said before the suit court that, my lord, their signatures has been forged by, my lord, them, as well as we are collusively acting, which has been held by the honorable court, my lord, that since there is an
But then
arbitration,
any kind of order which being passed by this court in your
will
section
not affect them, my lord. Will not affect them.
will not affect the
No, no, no.
the
It
dispute
will not
which is
affect
pending
them.
adjudication
No,
in
no,
the
no, no, no.
in the SLP.
No, no, no. Because they have allegations against the person I'm seeking orders for. So, my lord, kindly comes to, my lord, page 23, clause B, my lord. In the court, lordship has got clause. In the course of its business, hereinafter referred to as the principal, supplies, sells goods, and or renders services to various customers, including the borrower, from time to time, will kindly mark and raises invoices containing particulars of goods supplied and amounts due under such invoices in accordance with the terms of agreement between the principal and the borrower. So, my lord, the arrangement is very clear that, my lord, the borrower will, my lord, give us, my lord, the invoices.
Yes. Yes.
The borrower will give the invoices to us, my lord. And, my lord, we will make the payment to these third-party vendors. And in terms of this agreement, as it is quoted, my lord, the borrower will pay me off.
Yes.
Because the language is in accordance with the terms of the agreement between the principal and the borrower. The lender and the principal, then, my lord, see, the lender and the principal have an arrangement in terms of which the principal has inter alia agreed, this is very important, my lord, agreed to indemnify and recommend buyers from its network to the lender. Now, a case is being run, my lord, when the directions were given by my learned junior friends, is that, my lord, the vendors have changed. Therefore, I'm not supposed to pay. It is a separate agreement and separate arbitration clause. Lordship cannot pass any interim orders. But kindly seize the language, my lord. The lender and the principal have an arrangement in terms of which the principal has inter alia agreed to indemnify and recommend buyers. The language is S. Buyers from its network to the lender. So, my lord, the buyers will obviously change. For buyers to the network for the purpose of short-term financing from the lender. The lender will provide the facility defined below to the borrower, which money shall be considered as part as payment towards purchase of goods from the principal. Then D, relying upon the representations and information provided by the borrower in this agreement. This is also very important because I'll show the particular invoices which were being given to me for payment have come from the borrower only. The vendor has not sent me. So, my lord, it says, my lord, information provided by the borrower to this agreement, the lender has agreed to grant the facility to the borrower on terms and conditions hereinafter mentioned. So, therefore, my lord, what are the terms and conditions? Is that, my lord, one is that invoices would be raised by, my lord, a supplier. The borrower would send me those invoices. I am supposed to honor those invoices and make payment, and the borrower indemnifies to make good that money to me under this agreement. And the word is buyers, not buyer. Now, my lord, under such circumstances, my lord, I had disbursed amount in terms of page 24, clause 3.1. Kindly seize, my lord. Disbursement of facility. Subject to the terms of the facility document, the borrower shall be entitled to submit disbursement request. So it is again him. For such facility to the lender, the disbursement request shall be issued by the borrower no later than 1 business day prior to the proposed date of disbursement. Disbursement of the facility shall be made by the lender into the account of the principal as per the mode of disbursement as set out in the Schedule 2 in respect of the goods having minimum value set out in Schedule 2, and the date of remittance of the lender shall be date of the disbursement. So, my lord, he is supposed to, my lord, give me the, my lord, invoices. I am supposed to pay it to, my lord, the persons who are named in the schedule in as borrowers and also borrowers who would come in later on. Now, my lord, kindly sees repayment, 5.1, same page. The borrower shall completely repay. So, it is him who is going to repay me. The borrower shall completely repay the relevant tranche. My lord will kindly mark this word tranche because tranches are now, my lord, shown before my lord as an agreement. It is one agreement which has got several tranches, my lord. That is why the agreement, my lord, records a tranche and not, my lord, agreement. Kindly sees the borrower shall completely repay the relevant tranche of the facility along with applicable interest, cost, and charges as a bullet payment on the last day of the tenure unless extended by the lender at its sole discretion. This is because of the reason, my lord, he has a 90 days period to pay me the amount. Otherwise, my lord, interest charges would, my lord, incur. So, my lord, that tranche he has to pay me within 90 days time. Now, my lord, kindly sees in the event the borrower fails to repay the outstanding amount in the designated account on the last day of the tenure, that's the 90th day, my lord, the borrower shall be liable to deposit all outstanding amount into the along with the additional interest into the designated account no later than 1 business day from the expiry of the tenure extended repayment period. It is clarified that no notice or reminder shall be given by the lender to the borrower to repay the facility as per the agreed terms. So, my lord, on the 90th day, if he does not, then the entire money becomes outstanding. And I don't have to issue a notice for that. It's a demand which is, my lord, automatic. Then, my lord, kindly sees 5.3. The records maintained by the lender in its ordinary course of business shall be conclusive evidence for the due amounts from the borrower in respect of the facility. So, my lord, whatever, my lord, I show before my lord, obviously it shouldn't be contrary to the law or something which is not agreeable under the Contract Act. My lord, is a conclusive evidence, my lord, of the amount due and payable by them to us. Then, my lord, kindly sees, my lord, the events of default at page 25, my lord, 10.1. Because this is what I come before my lord for. Occurrence of any one or more of the following shall be treated as an event of default. Now, my lord, kindly comes to A, small a. Failure of the borrower to repay the outstanding amounts on the day of the tenor or before the expiry of the extended repayment period. So, therefore, my lord, the day the tenure of 90 days expires, if there is money due and payable, that will be construed as an event of default and the consequences would follow. And in this case, it's not a case that an extended period has been granted to them. So, my lord, 90 days is the cutoff date. Now, my lord, kindly comes to the governing laws. That's, my lord, page 26 and the arbitration clause, which, my lord, gives jurisdiction to this honorable court. That's, my lord, 15.1 at page 26. This agreement shall be construed in accordance with the laws of India and subject to the arbitration clause below, subject to the exclusive jurisdiction of the competent courts in Kolkata. That's, my lord, lordship's jurisdiction, my lord. And 15.2, if your lordship takes the last line, the situs of arbitration is also Kolkata. Lordship will find the arbitral award shall be final and binding on the parties. The seat and venue of arbitration shall be at Kolkata. So, lordship has got jurisdiction to that, my lord. There cannot be any, my lord, dispute with. Now, my lord, what is the amount and what is due and payable? Kindly comes to page 29. Because today, my lord, I have to just show before my lord, after affidavits, even my lord, a prima facie case for obtaining an interim order, which I am seeking for. Now, my lord, kindly sees the name of the borrower at the top. That's, my lord, the respondent number 1, Bharat Electricals Accessories P Limited. And kindly sees 3, which they, my lord, have been harping upon. Details of principal of the borrower is known as Vedanta Limited. Now, my lord, I'll show before, my lord, this is what they're trying to say, is that since it is Vedanta, the next tranche of money which I have requested you to pay under this agreement to, my lord, to other entities, therefore you are not covered under this agreement. That's their whole case. My lord, that does not stand because that's not the law of the land. Because the agreement says buyers. So the buyers, if he wouldn't have made a request, my lord, and I would have made to a third party payment, that would have been constituted, my lord, that is not under the subject matter of this agreement. But when he is making a request under this agreement, and, my lord, I am paying him, then, my lord, under this agreement, my lord, the disputes have arisen. I am entitled to an order because ultimately the arbitrator would decide whether I am entitled to that money or not. Now, my lord, there is one very important issue here also, is that, my lord, on the last occasion, Lordship had asked them, so therefore, if you are running this case, there must be other agreements with the, my lord, petitioner. I'll show from their affidavit, my lord. They have stated that there is no other agreement. They are silent about it. So that, my lord, makes out a clear case that there is only one agreement with my learned friend's client. And under that only he has made a request and I have paid. And there is no dispute, my lord, I'll show from their affidavit also, that I have paid an amount of more than 2 crores to that vendor at the request of my learned friend. I'll show that also. There is no dispute to that. Now, my lord, kindly sees the facility amount is, my lord, 6 is around 2 crores. Up to 2 crores is the limit. And Lordship will find, as Lordship was asking us, my lord, clause 14, the borrower is Bharat Electricals, then, my lord, Subhash Chandra Gupta, Sunita Gupta, Rekha Gupta, Manmohan. These are, my lord, 4 to 6, my lord. They say that the, my lord, first one has, my lord, forged the signature. That's, my lord, subject matter of the SLP, so I'm not getting into it. Now, my lord, kindly takes, my lord, apropos this, when I, my lord, finance them, my lord, for the amount of, my lord, 2 crores, my lord, kindly takes before that page 35 once, that will give the period of the tranche. It's not an agreement, it's the tranche which matters, which is been confused by saying that it's not a it's an agreement, not a tranche. Now, at the second box, Lordship will find facility amount of 2 crores. Lordship has found it, my lord. Second box, my lord. The first entry, in fact. Facility amount, my lord, 2 crores. Then, my lord, will find tenure of facility is 12 months. But, my lord, tenure of each tranche is 90 days. Lordship will kindly mark it. So 90 days is the cutoff period. After that, the entire money becomes due and payable under that tranche. Then Lordship will find interest rate is fixed. Rate of interest is 13.50% per annum. Now, my lord, apropos this, kindly sees, my lord, I had advanced them a payment of 2 crores initially. Now, my lord, that became due and payable. And, my lord, I had filed initially a Section 9 application under this agreement only, being AP number 39 of 2023, which came up before this court, my lord, in respect of payments made to Vedanta. My lord, Lordship will find, my lord, at page 73. এটাই তো না, এটা নতুনটা 73 টা নতুনটা, এটা নতুন। ওটা কোনটা আছে? Kindly takes, my lord, 68. That's at page 68, the initial. Kindly takes page 68, my lord. Now, Lordship will kindly take at the top, this is very important, loan account number. Lordship has got it, my lord, at the top, my lord, the third entry, my lord, at the top. Loan account number.
Yes.
At the top. My lord, will kindly mark the last 4 digits because, my lord, it's a big number. Last 4 digits, 0481.
Yes.
That is very important. That's the loan account number. Then the tranches would change. Loan account number is 0481, which would be constant. Statement date, my lord, is 1/4/2024 onwards. Now, under this agreement, my lord, under this statement, Lordship will find, my lord, I have provided amounts to Vedanta for 2 crores. Now, my lord, what happened is that এটাই তো এই চারটেই তো Vedanta তো এই চারটে Yeah. Now, my lord, will find, kindly now come to, my lord, page 73. My lord, at the third, my lord, column, this is, my lord, written as L1. Lordship has got it, my lord.
L1.
Yes, my lord, they are all L1. My lord, there the heading is closed tranche at the middle, my lord.
UGD 5158.
Yes, my lord. Now, my lord, kindly will mark, because this confusion will be tried to be created, so I'm clearing it now, my lord. Kindly see tranche loan number. So the tranche is UGD 15800. That's what's the tranche which was earlier of the section 9 AP. There, my lord, loan date was 1/8/2023. My lord, the entire 2 crores was paid and close date was 31/3/2024. That's, my lord, the 90 days period. So, my lord, when this became due, we filed, my lord, a section 9 application, wherein, my lord, after affidavits, my lord, it was decided by the honorable court that, my lord, under this agreement, under this tranche perhaps, no amount is due and payable. My lord, kindly takes page 117, which second volume, no? That's in the second volume, my lord.
Second one. Yes.
My lord, kindly takes 117. The judgment is, or the order is dated 12th of November 2024. Lordship will find this is an application under section 9 of the Arbitration and Conciliation Act. Then the prayers are quoted. Then, my lord, if your lordship, my lord, comes towards the middle of 118, there is a sentence which starts, the recall notice has been placed in detail. Lordship is found, my lord. Towards the middle of 118. The recall notice has been placed in detail at the middle, my lord, to show that an amount of 2 crores and odd was due and payable by the respondent against a loan account number. Again, lordship will mark the last 4 digits 0481. That's the agreement number. Now, my lord, will kindly come to, my lord, the relevant portion, because these are all submissions, to his submission at page 120. The second paragraph starts, my lord. Mr. Shah, learned advocate for the respondent number 1, draws the attention of the court to page 9 of the affidavit in opposition. The same is an email dated 24th April 2024. The email was written by a representative of the lender. Kindly now will mark, my lord, in respect of the loan account number 0481. So he agrees that, my lord, this is the loan account number. Mr. Shah's contention is that the email clearly indicates that the principal amount was no longer due, but only an interest of 22,000 such and such was due and payable. The principal amount was shown as 0. Reference was further made to the document at page 10, which showed the loan details. Sanction of 2 crores against application number. Now, my lord, kindly sees. This is his submission. Application number. He is no longer saying, my lord, loan account number. Now, in submission before my lord today, he is saying that it's the loan account. That can't be, my lord. That's contrary to what he has submitted before the honorable court before. Application number 15800, disbursed on August 1st, 2023. Pages 14 and 15 have relied upon to show that against the application number, again, my lord, 15800, lordship, which lordship saw, payments of 25 crores on 3 occasions has been made, and finally such and such on last occasion were made. Mr. Shah further refers to the disbursement made by the lender upon receipt of such payment and submit that those disbursements were in relation to other agreements and or transaction. Same case he tries to run there also. The money was sent to the other agreements and or transaction. So, my lord, these transactions which are now before my lord, he says that these are other agreements. The money was sent to the account of the respondent number 1 directly and not through Vedanta. They were not part of the loan agreement, which is the subject matter of this proceeding. Those were separate loan facilities and not the subject matter of arbitration agreement. Same case he's run there also, my lord. Reference has also been made to page 15 of the opposition to show statement and monthly interest status, the loan status against the application. Again, my lord, application number 15800 depicted the same as closed, which I showed to my lord, indicating that neither any interest nor any principal was payable. The closure was dated 31st March 2024. These documents relied upon by the respondent number 1 belong to the lender. Then, my lord, will kindly come to, my lord, the part where, my lord, the court, my lord, finds the, my lord, the facts of the case. My lord, page 122, the second paragraph. The question is whether the injunction as prayed for in this application should be allowed. From the affidavit in reply filed by the litigation manager of the petitioner, it appears that it is admission with regard to the payment claimed to have been made by the respondent number 1. The averments narrate that during the pendency of the application under section 9, petitioner approached by the respondents for reschedulement of the account by an email dated 19th March 2024. This is the email which Mr. Banerjee has placed reliance upon. In view of the request, the account of the respondents will kindly, my lord, mark, were restructured by the petitioner. A reference has been made in this regard to document 9 of the affidavit in reply. The same is an email dated April 24, 2024, written by the lender to the borrower. So he has written it to me, indicating that only the interest amount was due. The documents at pages 10 to 15 were statements annexed to the said email, which indicated restructuring. It has also been admitted by the deponent that the amount of rupees 2 crores which was paid on August 1st, 2023 is the subject matter of the arbitration agreement, and also the recall notice has been restructured. Paragraph 324 of the affidavit in reply clearly indicates so. It has been stated in paragraph 5, and after restructuring, further financial assistance was given to the respondents. And this is what I am before my lord for. They have defaulted in this. And fresh tranches were created in terms of the restructuring requested by the respondent. So, my lord, there is no fresh agreement. There is a fresh tranche of, my lord, payments made to the vendors. The disbursement dates have been mentioned at page 5. The loan agreement, kindly mark this, my lord. The loan agreement number is the same. So, the loan agreement does not change. The invoices have been mentioned along with the disbursement dates, which tally with the documents annexed by the respondent number 1 in the affidavit in opposition. So this is an admitted case, and they have not, my lord, gone up in appeal against this finding of the court. Thus, the respondent number 1 has made out a case of restructuring. So that is the case made out by them. Restructuring of the loan account, if not a case of payment of entire outstanding. There is a clear admission of such restructuring by the petitioner's officer. The restructuring took place admittedly after the application under section 9 has been filed. Fresh payments, disbursements were made by the lender on these dates. And these are the dates I'll show to my lord, what is before my lord I'm seeking an interim order for. The contention of Mr. Banerjee that the tenure of the repayment of the loan of 2 crores is expired on July 2024, and the respondents were sitting tight over the matter without payment of a single farthing has not been established. That's, my lord, the earlier one. And then the court comes to a finding, my lord, kindly comes to a little below that, my lord. The sentence starts with whether the money disbursed, kindly sees, my lord, whether the money disbursed on the above dates after restructuring have been repaid or not is not an issue before this court. Correctly, my lord, that section 9, this was not the issue. The lender may also proceed according to law against such outstanding, which have come before my lord. As of now, the prayer for injunction has to be restricted to the subject matter of the agreement, which has been annexed to this application from the records and the admissions made by the lender that the restructuring was done at the request of the respondent number 1. The court does not deem it either fit or necessary to grant an order of injunction in respect of prayer D. The subsequent events have been taken into account. The pleadings are not in consonance with the latest development. This court does not make any observation with regard to the steps the respondent may take in respect of the subsequent dates. In this proceeding, the petitioner has failed to premise. So therefore, my lord, what is the order or the judgment passed? That, my lord, in that section 9 application, the tranche which was paid that has been repaid. 22,000 was due under the same agreement. What have been paid during the pendency of the Section 9 application are fresh tranches on a reschedulement of that agreement, and that would be the subject matter perhaps of a future litigation, which, my lord, I have come up before my lord. Why I say this, my lord? Now kindly takes, my lord, the payment dates and the tranches. Lordship kindly comes back to page 73.
Have you invoked the arbitration? 11.6 you filed?
No, I have not filed because, my lord, I have not obtained any orders. My 90 days have not started as yet. My lord, kindly takes, my lord, page 73.
Yes.
My lord, this is the tranche loan status. Now sees at the middle. This is what is before my lord today. Not the one that is the closed tranche, which was the subject matter of the Section 9 earlier. Now, my lord, there are 5 entries. In fact, this was annexed. This I am showing, my lord, from them. This is their affidavit in opposition, which I have annexed to the petition. They, my lord, suppress 1 entry. There are 5 entries. My lord, kindly sees 1, 2, 3, 4. These are separate UGD numbers. This is 52533, 52738, 53031, 53506, in respect of which, my lord, I have paid the amount which are principal outstanding. And kindly, my lord, at the extreme, my lord, right hand side, lordship will see the due dates: 21/6/2024, 21/6/2024, 25/6/2024, and 26/6/2024. So these are beyond the period of the period, my lord, which was the closing date of the earlier one, which is just below that, 31/3/2024. That is why the court says these are transactions made during the pendency of the Section 9. Now, my lord, why I say they have given only 4? The last entry, lordship will find at 101. Kindly comes to 101, which they have not shown. My lord, 101 at the top, open tranche is the heading. They have the same 4 entries from the top, except the last one, 55077, another 1 crore, which lordship will see the due date at the left hand side, 9/7/2024. 9/7/2024. Lordship has got it, my lord. The last entry. I say, from the top, 5th one is what is not included by them at page 73.
Okay.
But that's also due and payable by 9/7/2024, which they have not. So all these 5, my lord, vendor entries are what is due and payable, and I'm seeking an interim order against at page 101.
Yes.
Now, my lord, why do I give this to them? Lordship will ask this question. If you have paid on your own, I have not paid on my own. This is the request made by them to me to make the payment under this agreement. Now, my lord, lordship will kindly come to page 82. Page 82, my lord. Kindly sees, my lord. Sorry, my lord. Kindly takes page 102, my lord. Kindly takes page 102, my lord. I'm extremely sorry, my lord. Kindly sees, my lord, the date on which at the top Bharat Electricals makes this request on 21st of March 2024, subject repayment request and then attachments. Now, my lord, obviously there can be, my lord, a submission made from the bar that, my lord, how is it that you're saying that this is the mail in respect of which these attachments were there? Because the attachments I have enclosed, the invoices from 103 onwards till, my lord, 111. 111. These are the new 5 invoices which totals up to that amount. So, my lord, I got my officer in court with the laptop. If your lordship wants, my lord, I can open this email and show that, my lord, it was sent to us by them, and from them I have got this mail, and I'll open it and show these are the attachments which have the invoices with me. If your lordship wants, my officer is there in court with the laptop, my lord. He can open it and show it to my lord.
Not
So, my lord, kindly sees it is at their request on 21st of March 2024 that these invoices are sent to me in terms of the agreement clause as I read out, my lord, and I have made the payment to them. So now they cannot turn around and say that, my lord, these are not under the same agreement. Now, my lord, kindly takes their affidavit in opposition. Kindly sees the stand that they take. My lord, I'm only dealing with 1, 2, 3. So, my lord, will kindly takes 1, 2, 3, my lord, the affidavit in opposition. My lord, at paragraph 3, they say, my lord, the usual ones: misconceived, false, untrue. Then, my lord, paragraph page 4, my lord. I'm sorry, my lord, page 4, paragraph 3. Paragraph 4, they say of the earlier section 9 application, which I have myself, my lord, disclosed. And, my lord, kindly will see the admission on their part at paragraph page 5. From the top, my lord, if your lordship leaves a few lines, there is a sentence which starts, my lord, this honorable court. Lordship has found it, my lord. Kindly sees the admission. This honorable court has further pleased to find that whether or not the further amounts disbursed by the petitioner to the respondent number 1 pursuant to the restructured facility has been repaid constituted questions of trial before the arbitrator. I don't think, my lord, that is what the order records. It's a interpretation made by them. The order only records that these are payments made during the pendency of the section 9, can't be a subject matter of that section 9, and therefore court doesn't get into it. Then, my lord, kindly sees they make out a new case that these are amounts given to Gupta Power and Gladiolus Microservices Private Limited. So therefore, my lord, this is a separate agreement, not to Vedanta, so not covered under this agreement. Then, my lord, kindly comes to, very important, my lord, kindly comes to paragraph 8, page 6. My lord, paragraph 8, page 6 are the bank statements that they have disclosed, saying that this amount has not come to me. Automatically, my lord, this amount will not come to them, but to the, my lord, vendors. Now, my lord, those enclosures, lordship will straight away come to, my lord, page 23. In fact, my lord, this helps me out. I'm grateful to my lord for calling upon the, my lord, affidavit, because this helps me out to show the earlier case also is established. There is no payment made in the statement of 2 crores under the earlier tranche also. Anyway, my lord, let me show it at page 23. Kindly now we'll see, my lord, how malafide they act. Kindly see the statement date of this particular account of Punjab National Bank, 1/4/2023 to 31/3/2024. This is the period, my lord, wherein I had, my lord, paid to Vedanta, and they say they have paid back. Although this is, my lord, just to show the malafide of their on their part. This, my lord, according to them, in the court before, my lord, when the section 9 was taken, we had requested them, and the court had requested them to disclose the bank statements. Then they did not. They did not. But, my lord, now, in view of my lord's direction, they have, and they are caught. Kindly sees, my lord, 1/4/2023 to 31/3/2024. My lord, they say, if I show that statement, that, my lord, they had paid that amount, just for my lord's, my lord, knowledge. Statement 83, if your lordship, my lord, remembers. Lordship may not take it out. This statement payment 73. Well, kindly takes one page. Lordship may not take it. 73. My lord, the close date there is 31/3/2024 of that 2 crores at page 73. I just want to show the malafide on their part, which they have done earlier also, and they're trying to do it now also.
Page 73?
Yes, my lord. If your lordship sees that closed tranche, that, my lord, amount, then, my lord, close date is 31/3/2023, and, my lord, they made a payment of 2 crores. That is what their case was. So nothing was due and payable. Now, my lord, in this statement, now kindly sees, this is from 1/4 till 33/2024. So this should at least, my lord, record, my lord, that 2 crores payment. There is no payment of 2 crores made to us even for Vedanta. Be that as it may, my lord, I'm not taking my lord into it, but I'm showing
You're
the.
not disputing that 2 crores that you have received.
I am. That's a, my lord, finding of the court. I will, my lord, argue before the arbitrator to show it in trial. But my lord kindly sees the intent. Now, my lord leaves this. Lordship comes to page 25. I hope, my lords, my lord, page is more legible than ours. At page 25, my lord, is a bank statement. My lord kindly sees the statement date. Now this changes. It is no longer from 2023. It is now from 1st of March 2024 to 31st of March 2025. And in this, they try to show all these statements, page 26 also. Then, my lord, the earlier period is not given. Then, my lord, the next at page 27. Then, my lord, page 28, that this amount has not been paid to them. Now, my lord kindly takes now the now kindly comes to, my lord, page 28. This, my lord, they enclose the, my lord, statement of the vendor. Statement of the vendor. So, my lord, this vendor is, their person is apparent because the vendor relies upon him so much, he's given the bank statement to him. So he can't say that he's not my person, go after him. So, my lord, he has very, my lord, with a, my lord, bona fide attempt, enclose, my lord, the statement to show that it is his vendor only. At page 28, kindly comes to, my lord, page 29 and see that, my lord, I have made the payments to his vendor. My lord, this is the entry from the bottom, 6th entry from the bottom. My lord, the date is 23/3/2024. Lordship has got it, my lord.
Which page? 20?
My lord, page 29. All admitted payments to his vendor. My lord, from the bottom, the 6th entry, 23rd of March 2024. That's the period recorded in the, my lord, date of the statement.
Yes.
Kindly sees, my lord, the payment 24,98,000. Lordship will mark it, my lord. And the name, my lord, the 5th entry, my lord, in the middle, Ugro Capital Limited. So they have received 24,98,000 being a vendor of the borrower. Then, my lord, the last entry on that page, 26th of March 2024, towards the middle, Ugro Capital, my lord, again 24,50,000. Third, my lord, second last line, second last column. Lordship has got it, my lord.
Yes.
Next page, Lordship turns, my lord, the second entry, 27th March 2024, middle, my lord, Ugro Capital. Then Lordship will find under the heading credit, 24,98,000 again paid to the vendor of him. Then, my lord, just leaves the next entry, the entry thereafter, 28th March 2024. Again, the petitioner pays, my lord, 25 lakhs credit. Then, my lord, the third last entry from the bottom, 28/3/2024, transfer by Ugro Capital, the petitioner, again 24,98,000, exactly the invoice amounts that has been forwarded to me by them and paid to them, my lord, added together. Now, my lord, therefore, it is an admitted situation that the amount has been paid in terms of the agreement by his vendor on a request made by them. Now, my lord, this case, if he cannot run, thereafter he comes with a new case where he says that since, my lord, I am an NBFC, I cannot claim, my lord, an arbitration relief before my lord. This is somewhat too far-fetched, my lord, and he has annexed certain, my lord, notifications at page 31 onwards of the Reserve Bank of India. Now, my lord, kindly takes, my lord, in fact, this is just the opposite. My lord, kindly takes, my lord, once the Surfacy Act. This is just the opposite. So he's running another case to save his clients. So now the stand is different because if he fails in that, because the documents are showing apparently an admitted situation that amount has been paid in terms of the agreement on a restructuring made by them at a request made by them with the vendor receipts given by him to me by his email. So he runs a different case now. Kindly take section 11 of the SURFACE Act, my lord. When I can come before my lord? Resolution of disputes. Where any dispute relating to securitization or reconstruction, my lord, kindly mark thereafter. Or non-payment of any amount due, including interest arising amongst any of the parties. It does not say bank versus bank or NBFC versus NBFC. If I am an NBFC, I have something non-payment of amount due, including interest, then, my lord, I can go for arbitration only. Namely, the bank or financial institution or asset or qualified buyer. So, my lord, here is a qualified buyer. Now, my lord, kindly see. Such dispute shall be settled. The word is shall be settled by conciliation or arbitration as provided in the Arbitration and Conciliation Act 1996. And if the parties to the dispute have consented in writing for determination of such dispute by conciliation of arbitration, and the provisions of that act shall apply accordingly, and not the SURFACE Act. So therefore, my lord, there is a written agreement with me, and my lord, I am entitled to, my lord, and proceeding under Arbitration Act before my lord. My lord, this came up with a lot of questions, my lord, before the Supreme Court, and the Supreme Court in its latest judgment in 2025 had made it very clear that, my lord, an NBFC can come, my lord, can only go. May I just hand over? This is reported in 2025 SCC, my lord, 9 SCC, page 225. Gives me one moment, my lord, just paragraphs, my lord, may I just find? My lord, kindly comes to paragraph 67, my lord. Very detailed judgment, my lord. My lord, paragraph 67, lord, she will kindly mark, my lord, records, my lord, or my lord, the section 11 of the, my lord, SURFACE Act. Then, my lord, kindly comes to paragraph 69. The object underlines section 11 of the SURFACE Act insofar as it mandates, kindly sees the word, my lord, very strong, mandates arbitration or conciliation as the only mechanism for resolution of disputes between a bank, financial institution, ARC, etc., and outs the jurisdiction of DRTs under section 17 for adjudicating such disputes as to ensure that ancillary or collateral disputes that may arise between competing secured creditors do not hinder the larger purpose of the SURFACE Act of the facilitating recoveries of dues from the borrowers expeditiously by enforcement of secured assets or other means provided thereunder. It is to ensure that discord among secured creditors should not impede, derail, or stall the recovery of proceedings under the SURFACE Act, which are designed with the idea of time-bound adjudication with minimal interference. Now, my lord, kindly sees paragraph, my lord, 79. Now, my lord, kindly comes to paragraph 79. My lord, kindly takes paragraph 79 once. It is manifest from the foregoing discussions that the present case at hand, more particularly dispute between the appellant and the respondent bank, does not pertain to either securitization or reconstruction. Very important, my lord. It does not involve any acquisition of financial assets or rights by an asset reconstruction company, ARC. Rather, the crux of the issue is whether the controversy involving the competing claims of rights over the stocks of good by hypothecation of pledge and the dispute therein falls within the scope of section 11 of the SURFACE Act, identical to ours. There is no SURFACE, my lord, issues regarding here. I am a lender, is a borrower, money is due and payable, I am supposed to, my lord, take it. And that's exactly, my lord, the crux of section 11. More particularly, the third category, the one that I read before, my lord, the third category of disputes delineated thereunder pertaining to non-payment of any amount due including interest. Then, my lord, kindly sees paragraph 80. The scope and meaning of the phrase non-payment of any amount due including interest used in section 11 of the SURFACE Act warrants careful examination. It is pertinent to note that the statute employs the term any amount, or it can be any sum, any amount, thereby reframing from limiting its application to a specific category of amounts that may be owed to a party mentioned in the provision. The expression any amount due including interest must be construed in the light of the purpose of the act and the provisions contained therein. The plain meaning of the term any amount due encompasses amounts that remain unpaid beyond the due date, and that's my 90 days period. However, the aforesaid is only one element of the meaning of the said expression. Then, my lord, the other, my lord, quotations are, the judgments are referred to. Now, my lord, kindly comes to paragraph 82. A situation of non-payment of any amount or an overdue arises when one party fails to fulfill their obligation to pay the party they are indebted to, just identical to our case. For the purposes of the present case at hand, we will be focusing on the scope of section 11 of the SURFACE Act, specifically in the context of disputes between two banks, excluding financial institutions, asset reconstruction companies, or qualified buyers, as otherwise contemplated under the provision. In cases involving two banks acting as creditor, a dispute may not arise directly between banks to the non-payment of any amount they owe to each other. Instead, disputes typically emerge because of the borrower's failure to discharge their debt obligations. For instance, if a borrower defaults on repayment after availing of credit facilities extended by two banks, issues of non-payment of loan amount including interest owed by the borrower, the same may lead to a dispute. Such a dispute is likely to concern a priority of charges over the borrower's assets, especially in situations where the borrower has secured loans from both banks by mortgaging the same property. In the present case, the question of priority arises due to the simultaneous loans extended by the appellant and the respondent banks and the creation of charges over the same security. In such cases as the present one, the authority to determine which bank holds the prior charge over the borrower's asset becomes a significant issue for consideration. There have been instances where such disputes have been referred to DRT or civil courts for adjudications. The question of determining the priority of charge typically arises out of the borrower defaults on their obligations and their assets are classified as NPA. In such scenarios, two or more banks may assert competing claims over the same secured assets. So, my lord, this goes on with regard to, my lord, the bank charges. Now, my lord, kindly comes to 85. It is imperative to carefully examine the bare text of section 11 of the SURFACE Act. The said provision does not stipulate that the amount due must be owed directly between two banks, financial institutions, ARCs, etc. The language of the provision is clear and discernible where any dispute relating to non-payment of any amount due, including interest, arises amongst any. The broad phasing of the aforesaid expression signifies a wide import of its meaning, which would include various range of scenarios where disputes are connected to unpaid amounts, including those arising due to, my lord will kindly mark, third party defaults. That's exactly what the case is trying to run. Third party defaults, such as indirect defaults of the borrowers. So, my lord, this hue and cry that he was making that it's not Vedanta, it's two others, my lord, that would not last, because, my lord, that is also covered under, my lord, any amount under section 11. For illustration, then, my lord, an illustration is given. I'm not, my lord, reading, kindly comes to 87. Thus, it follows that where the dispute between the bank is fundamentally related to the non-payment of any amount due, including interest, which may be triggered by the actions of a borrower, Section 11 of the SURFACE Act would apply. Consequently, such disputes being those which fall squarely within the ambit of the said provision would mandate, kindly see the language, my lord, would mandate the resolution of such disputes through the mechanism of conciliation or arbitration as provided under the 1996 Act. This interpretation aligns with both the language, the legislative intent behind Section 11 and the avoid object and spirit of the SURFACE Act. So, my lord, I think this makes it absolutely clear, my lord, that my lord, I am entitled to a relief before my lord. I don't have to go before my lord the SURFACE tribunal, my lord. Now, my lord, he has run another case that, my lord, this is, my lord, given to a party, my lord, who is not a party to this agreement. So, my lord, I have shown before my lord that, my lord, this is a, my lord, payment made pursuant to his request. So, my lord, here the concept of third party will not come because I have not paid them at their request. So, my lord, the issue is that had it been a case where I would have paid to a third party without a request from him.
No, but from the counter, if you can, from the affidavit in opposition, it also
Yes.
shows that tranches have been made to Gupta, tranches have been made to Gladius or
Yes,
whatever it is.
yes.
So to identify that the amount has been credited to only one particular or two particular, so we don't know the status.
Yes, my lord, I know the status.
Initially, when you had filed a Section 9, the only reason why the court was not inclined to grant you a relief is because the amount stands settled. That 2 crore, though today you are saying that even that has not been paid, and
I will not trouble my lord with
where
that.
it is reflected, that is what your stand is. But then the court was of the firm belief that the amount has already been paid, the account stands settled, and that is the reason why the relief was not granted to you. Now here,
And one more thing, if I may add there, my lord.
Borrowers are concerned.
Yes.
The parties which are, in dispute over here, you have to show from the pleading that who are those parties in whose account the amount has actually been credited.
Right.
And whether those tranches have been paid, not paid, is again a question which can be raised here too. I don't know what they have to say.
Yes.
See it
Now, my
after
lord,
the submissions.
absolutely, my lord.
But that can always be.
Yes. Now, my lord, the first thing is that, my lord, to add to what fell from my lord, is that the honorable competent court, my lord, had stated that, my lord, these tranches which are before my lord today are payments made during the pendency. So that Section 9 will not interfere. That comes to a close.
Right.
Now, my lord, I showed to my lord under this agreement numbers he agrees because the other judgment
Agreement
records.
number is 481.
Yes.
That is what.
And under the tranches, he says it's restructured, new payments. Now, my lord, that is an admission on his part, finding which is recorded in the last judgment, which he has not, my lord, got any modification of. That attains finality. Secondly, my lord, is that I have shown to my lord at page, my lord, mail ta bolo, page ta 102, wherein he makes a request to me to, my lord, pay these particular vendors in respect of which he has taken services. That's at page 102. That is, my lord, the mail dated 21st of March 2024. Kindly sees, my lord, subject to repayment, subject is repayment, my lord, sent from Bharat Electricals on 21st of March 2024. Attachment are these, my lord, invoices, which are, my lord, running from again till 103 to 111. I have enclosed thereafter. Kindly sees, my lord, the language. Dear sir, please find the attached PIs for your reference. These are the invoices, my lord, which have been enclosed. Now, my lord, just keeps this page open and takes the statement that he has enclosed, my lord, in his opposition, which I was showing to my lord, which clears my lord's second query, my lord, that this amount has gone to these vendors only at his request. Kindly takes, my lord, page Gupta Power
28.
28. Yes, my lord. I'm grateful to my lord. 28. This is, my lord, dated from 1st of March 2024 to 31st of March 2024, and, my lord, the request mail is of 21st of March 2024 at page, my lord, 102. Now, my lord, kindly comes to page 29. The first entry, lordship, which lordship has marked, kindly sees, my lord, made to Gupta Power on 23rd of March 2024. So, 21st he makes a request. One day, that was the language in the agreement. 22nd gone. 23rd I made the payment to Gupta Power of 24,98,000. Lordship has got, my lord. My lord, the entry on page 29, that's, my lord, the sixth entry from the bottom. Lordship must have marked it, my lord.
Sixth entry from the bottom is you, right?
Yes, I am paying to Gupta Power because he has been very kind to all of us. He has enclosed the, my lord, statement of Gupta Power at page 28, which shows it is his vendor and is not a third party. And, my lord, 29 from the bottom, the sixth entry, 23rd March, that's one day after his mail, I have paid to his vendor 24,98,000. Just one day. That's, my lord, the language. Then, my lord, last entry I have paid on 26th of March. Again, my lord, 24,50,000. Then, my lord, next page, page 30, as I showed to my lord, the second entry, 27th of March 2024, I have paid 24,98,000 again. That's after the mail. Then the fourth entry, 28th of March 2024, I have paid again 25 lakhs. And the third last entry at that page, my lord, 28/3/2024, again I have paid 24,98,000. So that is all after the mail of 1st of March 2024, request made by them. So therefore, my lord, I have paid the sums which are there and the invoices which I have enclosed, my lord, given by them from 103 to, my lord, 111. My lord, maybe a little here and there, 1 lakh, 2 lakh, maybe here and there. But, my lord, the amount has gone to them because I have to show a prima facie case. Now, my lord, therefore, this, my lord, case run by them that they are third parties, my lord, perhaps in this case that cannot be said because these are parties introduced by him under clause A and B of page, my lord, 23 of the agreement.
This is within 1 year of the agreement.
And also, this is within 1 year of the agreement because the tenure of the agreement was 12 months. And the agreement date, my lord, will kindly see is, my lord,
And what is the SLP which is pending?
my SLP is only with regard to 4, 5, and 6,
That's
where, my
right.
lord, these people say that, my lord, they collusively with us has, my lord, got their signatures forged. They did not, my lord, agree to this agreement being entered into between the parties for borrowing this money.
But digitally it is possible.
So, my lord, there I showed, my lord, that it is a digital signature, and under the Income Tax Act, my lord, digital signatures cannot be forged, first of all. But be that as it may, the court held that since there is an arbitration clause, we had filed a 5 and 8, you have to go before the arbitrator to, my lord, make these, my lord, allegations, my lord, and for adjudication. Against that judgment, they have come up, my lord, they have gone up in SLP, saying that that has got nothing to do with the interim relief I'm seeking. And, my lord, that order I have annexed at page 161 of my petition, my lord. So, my lord, as it fell from my lord, I must, as I showed, my lord, these are all payments made at his request on 21st of March. And, my lord, since, my lord, there can be a submission made that these are not those attachments. So I got my officer in court, he can show it, my lord, to my lord, opening the same email that these are the attachments. Attachments cannot be, my lord, manipulated when it comes from them. I can show it. So that case, my lord, of a third party, my lord, cannot be run here. Now, my lord, now, this would be purely academic. In fact, my lord, now the Supreme Court has also said that, my lord, if a third party is getting some benefit, my lord, under the same agreement, or, my lord, he's been prejudiced under the same agreement, that third party, against that third party, orders can be passed by the court also as on interim measures and by the arbitral tribunal also. So even if he says they are third parties, my lord, orders can be passed.
Yes.
So therefore, my lord, what I am asking for is now, and the third thing, which is very important, which, my lord, lordship has inquired, they have not run a case here, at least before this court now, that this amount of around 2 crores and odd has been paid back by them. In the entire affidavit, my lord, of the opposition, they have not, my lord, shown any statement that, my lord, they have paid back this amount, or any pleadings also that this amount has been paid back. Their only pleading is that it is a third party claim, you have to sue them, and that is my lord, NBFC.
It will be decided in your
Yes. Yes. And it's not a third party claim, because that's the, my lord, agreement. He will bring in the invoice, I will pay. So, my lord, today, if it is in place of Vedanta, if he says it's not Vedanta now, it is somebody else. So, my lord, then he has to show, simply before my lord, that this email he has not sent, which I had shown, my lord, to my lord of 21st of March 2024. In his pleading, he does not deny this email, my lord. Lordship can record it in his pleading. He does not say that that email was not forwarded by me. He could have run that case that this is not to Vedanta. Then, my lord, he has to show that he has not made a request. I have only made payments under the request made under this agreement. The agreement is one. Now, my lord, there is the prayers which I have sought for before, my lord, if your lordship kindly sees now. I am, my lord, asking for a very innocuous prayer, if I may say, my lord, kindly takes the prayers once. Kindly sees, my lord, prayer E. I am only seeking, my lord, that the withdrawal of this amount, without keeping, my lord, aside this amount, my lord, the bank accounts in annexure H, which I have stated, my lord, if your lordship takes annexure H once. That's at the last page, I think, my lord, page 1, volume 2, page 176. Your lordship kindly takes, my lord. My lord, these two accounts, I am stating, my lord, that there should be an injunction in respect of these two accounts, that without keeping a sum of 2 crores and odd, my lord, they should not transact. I am not saying they should not transact the account. They should, they can, but without keeping this amount, they should not. That's only the, my lord, interim order that I am seeking for at this moment, so that, my lord, I can, my lord, go before the honorable tribunal and have my disputes adjudicated, my lord. That's it. My lord, those are my submissions.
Let me come back. I'll hear it.
Very good.
I'll be back.
1 minute, just 1 minute. Is that, my lord, Lordship had asked them on the last occasion to show if there is any other agreement during that period. Since they argued that, my lord, there is no other agreement, my lord, which they have disclosed. Only now they say take a new plea that there is an oral agreement. This is neither here nor there. Can't be an oral agreement during that period with them. And I've shown the request made by them to make the payment. And the second thing is that, my lord, the invoices which are annexed to his, my lord, mail, which runs from 101 to 111, my lord, he has given several invoices. Now, my lord, I am only subjected to pay 2 crores only. I'm not supposed to pay more than that to him. That's my limit as I showed in the agreement. So what I have paid, my lord, are the invoices from 107 to 111 of my petition, my lord.
You're only talking about those 5 invoices.
Yes. He has, my lord, forwarded me, if that mail is opened before my lord. There are several invoices which runs from 101 to 111, but I am subjected to pay only 2 crores. I can't pay more than that. That's my limit. So I paid from 5, my lord, which starts from 107 to 111, my lord.
The one which you have pointed out in the letter also of March.
Yes, 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 my lord. Yes, my lord. Grateful.
My lord, may I start by kindly drawing your lordship's kind attention to the master facility agreement again.
Yes.
That is at page 23 of the petition. My lord, it is an admitted fact today that disbursements have been made, my lord, either under the first tranche, which was the subject matter of the earlier Section 9 application disposed of by the coordinate bench, or the present, my lord, Section 9 application, that, my lord, disbursements have not been made to the respondent. That is admitted. So my clients have not received any money under the master facility agreement. Agreement envisaged that there is a named principal who is my vendor, who will be supplying materials to me and raising invoices on me. Those invoices will be forwarded by me to the petitioner. Petitioner then will make direct disbursement to my vendors. And that will, my lord, be in pursuance of the terms of this agreement. Now, my lord, contention is only this, that, my lord, the named principal in this agreement is an entity by the name of Vedanta. Vedanta is my vendor. He is supplying raw materials to me and raising invoices on me. I am forwarding these.
Only one. There are many.
Kindly see this. That is why I wanted to draw your lordship's kind attention to the agreement itself. The named principal for whose repayment this facility is executed is only one, by the name of Vedanta. Lordship will kindly see the schedule to this agreement that starts, my lord, at page 29. Your lordship will kindly have page 29, second schedule, serial number 3, details of the principal of the borrower, Vedanta Limited. Lordship will also kindly see serial number 10, my lord, the purpose. The facility will be utilized to purchase the stock from Vedanta Limited. Now, my lord, whether there are subsequent tranches of this facility or not, my lord, there is no amendment to the schedule. That is very material. There is no amendment or no corrigendum that supplants the name of the principal or some other vendor in place of Vedanta. So it is only for goods procured from Vedanta that this facility is applicable. It is only for payment against invoices raised by Vedanta forwarded by me to the petitioner that, my lord, transactions are governed by this facility agreement. Now, my lord, will kindly see, come back to the agreement itself, which is at page 23, my lord. The date of the agreement is 25th July 2023. Your lordship will kindly take the recitals A, B, C, D. The lender, being a systemically important non-deposit taking NBFC, is engaged in the business of inter alia lending and is registered as an NBFC with the Reserve Bank of India. B, in course of its business, hereinafter referred to as the principal. So it's left blank here, my lord, to be filled in from the name of the principal mentioned in the second schedule, that is Vedanta Limited. So the principal supplies and sells goods and or renders services to various customers, including the borrower from time to time, and raises invoices containing particulars of the goods supplied and amounts due under such invoices in accordance with the terms of the agreement between the principal and the borrower. The lender and the principal have an arrangement in terms of which the principal has inter alia agreed to indemnify and recommend buyers from its network to the lender for the purpose of short-term financing from the lender. The lender will provide facility. The lender will provide the facility defined below to the borrower, which money shall be considered as payment towards the goods from the principal, purchase of goods from the principal, relying upon the representations and information provided by the borrower in this agreement, the lender has agreed to grant the facility to the borrower on the terms and conditions hereinafter mentioned. And thereafter, my lord, if your lordship will kindly take clause 3 of the agreement, that is at the next page, page 24. It says, subject to the terms of the facility documents, the borrower shall be entitled to submit a disbursement request for each facility to the lender. The disbursement request shall be issued by the borrower no later than 1 business day prior to the proposed date of disbursement. 3.2. Disbursement of the facility shall be made by the lender into the account of the principal as per the mode of disbursement set out in the Schedule 2 in respect of goods having a minimum value as set out in Schedule 2, and the date of remittance by the lender shall be the date of disbursement. Then, my lord, clause 6 is appropriation of payments, and if your lordship will kindly take the arbitration agreement contained at clause 15 at, my lord, page 26 of the petition. This agreement shall be construed in accordance with the terms of the laws in India and subject to the arbitration clause below, shall be subject to the exclusive jurisdiction of the competent courts situated in Kolkata in the event of any dispute or difference between the parties under this agreement, including in relation to the construction or interpretation of this agreement, or as to the rights, duties, liabilities of the parties arising out of this agreement. The disputes or differences shall be resolved through arbitration, which shall be administered by an institution recognized by the Government of India. For dispute resolution, such institution will appoint the arbitrator for the conducting of the arbitration proceedings in accordance with its rules for conduct of arbitration proceedings under the Arbitration and Conciliation Act 1996, as may be amended from time to time. Then, my lord, the procedure for appointment of arbitrators is there. So, my lord, what I would like to draw emphasis on is right at the outset, my lord, it says that this facility is only for, it is a line of credit facility, my lord. It is for, my lord, making payments of the principal, payments due to the principal for goods supplied by the principal to the respondent, before your lordship. Principal is named as Vedanta only. My lord will also kindly see clause C of the recitals, again at page 23. It says the lender and the principal have an arrangement in terms of which the principal has inter alia agreed to indemnify and recommend I beg your pardon, identify and recommend buyers from his network to the lender. So, my lord, it is only the principal here who is the subject matter, who is entitled to receive any payments or disbursement of facility under this facility agreement dated 25th July 2023. Now, my lord, no portion of an agreement can be treated as a useless surplusage. This is an established canon of, my lord, interpretation of deeds and documents. Lordship has seen the schedule at page 29. It categorically says, my lord, it is only for payment of goods purchased from Vedanta that this facility is executed, my lord. That cannot be read away or omitted. Now, my lord, admitted position that, yes, I have made a request to the petitioner to make certain disbursements from, my lord, Gupta Power Technologies Limited against invoices raised by Gupta Power Technologies Limited to me. My lord, the petitioner would contend that that in effect amounts to a modification of the terms of this facility agreement and brings the invoices raised by these other third-party vendors within the fold of this facility agreement. My lord, empowering the petitioner to disburse against to these third-party vendors against the invoices that they have raised to me, and, my lord, claim from me recovery of those amounts that they have disbursed. With respect, my lord, that will amount to a rewriting of the contract, which even the arbitrators cannot do. Because, my lord, the express terms of the contract, my lord, cannot be novated by any other subsequent correspondence or oral agreement between the parties. Section 91-92 of the Evidence Act bars this. Now, my lord, so admittedly, they have made disbursements to Gupta Power Technologies Limited. They are seeking repayment of this. Now, my lord, these payments, yes, some of these payments are outstanding. Some of these payments, my lord, we are attempting to, my lord, restructure. We have approached the petitioners again asking for more time to pay or asking, my lord, for an OTS. This is under consideration. But in the meantime, my lord, the question that arises for your lordship's kind consideration is whether, my lord, disbursements made to these third-party vendors against invoices raised on me, my lord, even forwarded to the petitioner, whether those, my lord, satisfy the definition of transactions which are amenable to arbitration as per clause 15 of this agreement. Now, my lord, if your lordship will kindly see page 103 onwards of the petition, my lord.
So where will you go? The promises which have been made by you.
Yes.
In terms of the fact that any invoice which is being raised,
yes, my lord,
you are liable to make the payment for it.
I cannot dispute that. If money has been disbursed, I am liable to
should
pay.
go somewhere else.
My lord, if it
Not
is
under this contract?
it is not governed by the arbitration clause in this contract, he will have to file a suit or approach the recovery of debt due to my lord, debt recovery tribunal. That is my contention. If your lordship will kindly see, my lord, there is a notification of the RBI in this regard which is relevant. I have, my lord, annexed it in my opposition. If your lordship will kindly have it. This is at page 31. Page 31 of my opposition, my lord. 18th February 2013.
Yes.
My lord, this is promulgated on the 18th of February 2013 by the Reserve Bank of India. These are the guidelines on fair practice codes for NBFC and the grievance redressal mechanism, the nodal officer. Your lordship will kindly take the next page, page 33. Kindly see, my lord, II in the middle of the page, loan appraisal and terms and conditions. The NBFC should convey in writing to the borrower in vernacular language as understood by the borrower by means of sanction letters or otherwise the amount of loan sanctioned along with terms and conditions, including annualized rate of interest and method of application thereof, and keep the acceptance of these terms and conditions by the borrower on its record. As complaints received against NBFCs generally pertain to charging of higher interest or penal interest, NBFCs shall maintain the penal interest charges for late payment in bold in the loan agreement. It is understood that in a few cases, borrowers at the time of sanction of loans are not fully aware of the terms and conditions of loans, including rate of interest, either because the NBFC does not provide details of the same or the borrower has no time to look into detailed agreement. Not furnishing a copy of the loan agreement or enclosures quoted in the loan agreement is an unfair practice and could lead to disputes between the NBFC and borrower with regard to the terms and conditions on which the loan is granted. NBFCs are therefore advised to furnish a copy of the loan agreement, preferably in the vernacular language as understood by the borrower, along with a copy of each of the enclosures quoted in the loan agreement to all borrowers at the time of sanction or disbursement of the loans. And if your lordship will kindly take, my lord, page 39 of the opposition, that is a continuation of, my lord, this circular of the RBI. Paragraph B says, in the loan agreement, the following shall be disclosed. So these are the requirements that, my lord, are required to be enumerated clearly in the loan agreement. So from this, my lord, two things transpire. That, my lord, even the Reserve Bank of India is cognizant of the fact that NBFCs sometimes, my lord, carry on business and disburse amounts to borrowers, my lord, without a written loan agreement. And this practice has been discouraged and deprecated. To remedy this situation, my lord, it is now incumbent upon the NBFCs to carry out all transactions pursuant to an express written loan agreement containing the following particulars. In this case, my lord, disbursements to Vedanta, the named principal in Schedule 2 of the facility agreement, have been made pursuant to that agreement only. Yes, there are other transactions between the petitioner and the respondent. Yes, they are also, my lord, underwriting invoices raised on me by other third-party vendors. But that, however, my lord, is not governed by this facility agreement. They are governed by an oral agreement that is contemplated under Section 9 of the Contract Act. But, my lord, this practice is not condoned or does not receive the blessing of the RBI. But this is something that prevalently happens, and to rectify the situation, RBI has found it necessary to, my lord, issue a directive. So, my lord, I place reliance on this only to show that merely because I have requested the petitioner forwarding him other invoices raised by other third-party vendors on me and ask them to make payments against those invoices, that does not bring those transactions within the fold of this facility agreement, my lord. Yes, they may be dues recoverable to the petitioner, my lord, but that will have to receive the adjudication in a separate proceeding, my lord. That cannot, my lord, be brought within the fold of the arbitration agreement contained in clause 15 of this agreement, my lord. Also, my lord, one decision I would like to rely on in this context is the decision of the Supreme Court reported in 2024 7 SCC 174. May I hand up a copy, my lord? This is a case, my lord. I'll just give your lordship the proposition on which I'm relying. In this case, my lord, the Supreme Court considers Section 7 of the Arbitration and Conciliation Act. What had happened here, my lord, is there is an agreement and then there is a subsequent agreement, say a supplementary agreement or a modification of the original agreement, which says that apart from the clauses expressed here and above, all other provisions of the original agreement will continue to remain valid and binding. So the question was, my lord, the original agreement has an arbitration clause. The subsequent agreement, that is supplementary or modification, does not have an arbitration clause. So the question before the Supreme Court was, will the arbitration agreement in the original agreement automatically, my lord, stand imported by reference or incorporated by reference into the subsequent agreement? And the Honorable Supreme Court has been pleased to hold that no mere reference to the general terms of the original agreement is not sufficient to import the arbitration clause contained therein into the subsequent iterations of the agreement or the amendment or the supplementary. There has to be a specific incorporation of the arbitration clause. If your lordship will kindly allow me to place from paragraph 14 onwards, my lord, that is at page 178 of the report.
How does it help?
Only to show, my lord, that in this case, there is an arbitration clause only in this facility agreement. Any other transactions between the parties are not amenable to, my lord, arbitration through invocation of clause 15 of the facility agreement. Even, my lord, if there were two different agreements, express written agreements between the parties, subsequent agreement says, apart from these aforesaid provisions, everything else contained in the original agreement will continue to operate and bind. Even then, my lord, the petitioner would not have the recourse of arbitration under the original agreement if not expressly incorporated into the subsequent iterations of the agreement. Any amendment or modification or supplementary agreement does not automatically stand, my lord, covered under the arbitration clause in the original agreement. That is the view of the Supreme Court. There has to be express, my lord, manifestation of intent of the parties to subject transactions under the modified agreement or supplementary agreement or corrigendum agreement to arbitration mechanism provided for and agreed to in the original agreement. In this case, my lord, arbitration is only for disputes arising out of transactions carried on under the facility agreement of 2023, where Vedanta is the named principal, only for payments, disbursements made to Vedanta. My lord, any other dispute is not amenable to arbitration under this agreement. Now, my lord,
Let us read the arbitration clause.
Yes, my lord.
B.
Yes, my lord, at page 26.
Page 23.
23. Yes, my lord.
In the course of its business.
My lord. In the course of its business, hereinafter referred to as the principal.
Go slow.
I beg your pardon, my lord. In the
I'm
course,
not very quick on uptake.
I apologize.
I take time.
I apologize, my lord. In the course of its business, hereinafter referred to as the principal, supplies or sells goods and/or renders services to various customers, including the borrower, from time to time, and raises invoices containing particulars of goods supplied and amounts due under such invoices in accordance with the terms of agreement between the principal and the borrower.
So what is your understanding of this? Any invoices which is raised by the borrower.
Yes, my lord.
One of the borrowers is the person who has raised those 5 invoices.
Yes.
Payment has to be released on the assurance of the principal.
Yes, my lord.
Principal is Vedanta.
Principal
so how
is
they are not covered by this contract?
My lord, principal is named Vedanta. Now that provision of the contract cannot be omitted.
Who are the borrowers?
Borrower is only me.
That's what I'm saying.
Yes.
So they are covered or not covered? On the basis of the invoices only the payments are being released?
Yes, my lord.
Right?
Yes.
All the payments earlier also are being released. Your own reply wherein you had put the bank account details of Gupta.
Yes, my lord.
Which is on page 28.
Yes.
Reflects that you have been receiving payment under this contract.
Yes, my lord. I cannot dispute that. Payments have been made. I have forwarded the invoices
So
of
if
Gupta.
you have been receiving payments under this contract, under this facilitation agreement which is in existence, so today the scenario changes.
With respect, my lord, I have received payment. My vendor, Gupta Power Technologies Limited, has also received payment against the invoices that I have forwarded to the petitioner.
Yes.
But that is a step.
today
But that is not under this agreement, my lord. My
Which is
contention.
the agreement, you show the agreement, and that is what had fallen from this court.
The
on the first
agreement
date.
is an oral agreement which is envisaged by the RBI, my lord, and that without
Where is
an
that oral agreement? Oral agreement, just oral agreement. Huh?
Yes, my
All
lord.
Very.
The RBI notification says that the NBFCs are disbursing monies without an express written agreement, and that practice has been discouraged, my lord. The RBI is cognizant of this fact. So, my lord, there is.
Where have you stated there's an oral agreement?
My lord.
Since when do you have an oral agreement?
Kindly allow me one moment, my lord. At paragraph 5, if your lordship will kindly take in my opposition.
Yes.
Running page 5, my lord, I have said at paragraph 10 of the instant application, the petitioner alleges that further amounts have been disbursed by the respondent number 1 against invoices raised by one Gupta Power Technologies Limited and purported invoices raised by Gladiolus Microservices Private Limited. At paragraph 15 of the application, the petitioner alleges that against such further disbursements made by the petitioner to the respondent, a sum
Where's
of...
the oral agreement word used in your affidavit in
Kindly allow
opposition?
me one moment. my lord. Check once. Kindly see paragraph 15 of my opposition also, my lord, at page 9. Here I have said, my lord, refer to the guidelines that I've just placed before your lordship. The guidelines on fair practice code of NBFCs issued by the Reserve Bank of India, V-Rate circular dated 18 February 2013, copy annexed, clearly provides that all non-banking financial
Where have you
companies...
stated, sir? In that paragraph, where have you stated there's an oral agreement?
My lord, what I have stated here...
Where have you stated in your reply?
I'm checking. My lord, kindly allow me one moment.
Sure.
Kindly see paragraph 16, my lord. This is what I have said.
Yes.
15 also, my lord. I've said that these are not covered by this agreement.
Where have you stated there's an oral agreement?
Phrase oral agreement has not been used, my lord, but what I have said is not under this agreement, that there are other transactions between the parties. That is what I have said. And my lord, that is not unheard of, my lord. The RBI is cognizant that these kind of transactions are in fact taking place. Now, my lord will also kindly see from the statement of accounts also from paragraph 72 of the petition, my lord.
Paragraph?
I beg page 72, my lord. The statements that have been disclosed in the petition. At page 72, my lord, it is alleged that serial numbers 283 to 295 are the fresh disbursements that have been made pursuant to this facility agreement, my lord, which gives rise to the cause of action for the present petition before your lordship. Now, my lord will kindly see, I have indicated previously also that the loan application numbers for the previous tranches were, my lord, 15800. If your lordship will kindly see serial number 282, these were for disbursements made to Vedanta, my lord. 23rd March 2024, paid against UGD 15800. Thereafter, your lordships will kindly see 283. This is allegedly the cause of action for the present petition. My lord, disbursement is made on the 23rd of March 2024. Application number is UGD 525333. Then again 287, my lord, application number 52738. Again, next item 52738. Again, my lord, serial number 292. Again, the application number is different, 53031. This also, my lord, corroborates my submission that these transactions, my lord, are not made pursuant to the terms of the facility agreement before your lordship. These are separate, unrelated transactions, my lord. Transactions of similar nature, invoices being raised by my vendors on me, I am forwarding it to the petitioner, but those are not governed by this agreement, my lord. And my lord, merely the arbitration agreement contained in clause 15 of this facility agreement cannot be resorted to, my lord, for resolution of any dispute arising out of these separate, unrelated transactions. The parties are different, my lord. The vendor is different. And it is not alleged that the vendor is my related party in any measure. Separate vendor who I am, my lord, procuring materials. Lordship will also see, my lord, the schedule that has been disclosed at page 175 of the petition. Here, my lord, these are the invoices against which the petitioner says it has now made disbursements to Gupta Power Technologies Limited, which gives rise to the present cause of action.
Yes.
Lordship has seen, my lord, there is one invoice that they have disclosed also raised by Gladiolus upon myself. This invoice, however, my lord, there is no correspondence showing that I have forwarded to the petitioner. So, my lord, that again is a completely unrelated transaction. There is one email that the petitioner has shown your lordship showing that these 4 invoices of Gupta Power have been forwarded by the respondent to the petitioner asking for disbursement of payment to Gupta Power. That is an accepted proposition.
So
But
if that is accepted, then
my
you
lord, whether
secure
it,
him to that extent.
I beg your pardon, my lord.
Secure him to that extent.
My lord, but that is not amenable to arbitration before your lordship under clause 15 of this agreement. That is my most humble submission, my lord. Whether that has been repaid or not, my lord, or restructured, that has to receive adjudication in a different forum. That is not, my lord, amenable to arbitration here, my lord. Even the Supreme Court says when there are two agreements, my lord, one contains an arbitration clause, the other does not. You cannot import the arbitration clause in the first agreement or in the former agreement to cover, my lord, disputes under the subsequent or different agreements.
Okay. Anything else?
Aside from this, lordship will kindly see from this chart at page 173 itself, my lord, that these at 175, I beg your lordship's pardon, my lord, that the amounts under these four invoices are alleged to have been due from as far back, my lord, as July 2024.
Yes.
From the fourth column, lordship will find that, my lord. The petitioners had, my lord, invoked arbitration previously, my lord, which has been disposed of by, I beg your pardon, invoked section 9 of the Arbitration and Conciliation Act, my lord. That application has been disposed of by the coordinate bench by its judgment of 12th November 2024. As far back as that, they say, my lord, these amounts are still outstanding, and, my lord, they relate to transactions carried out under this agreement. There has been no attempt to, my lord, invoke arbitration since then. Over 1.5 years have transpired, my lord. There is no tearing urgency with which the petitioners approach your lordship. My lord, for interim relief, especially, my lord, for attachment before judgment or, my lord, injunction under order 39(1)(b), where they, my lord, want injunction on my bank accounts, the conduct of the parties becomes relevant. Kindly see, my lord, they have, my lord, been in this torpor for 1.5 years. They have not, my lord, found it necessary either to invoke arbitration or, my lord, proceed before the arbitrator in a section 17 application. Aside from that, my lord, kindly see my conduct. The coordinate bench in its judgment of 12th November 2024 has been pleased to hold, my lord, that a sum of 2 crores that was disbursed to Vedanta stands repaid, barring interest of about 21,000 rupees. So, my lord, I am a diligent borrower, my lord. I have not, my lord, it's not that I am running away. The averments that, my lord, I am trying to deal with my assets or run away, my lord, completely unfounded. Kindly see my conduct and kindly see the conduct of the petition. My case is this, my lord, that these transactions are not amenable to the arbitration clause in this facility agreement. They're separate, unrelated transactions, my lord. And that apart, my lord, I also had a point that, my lord, if the petitioner is a designated financial institution under the meaning of the SARFAESI Act or the RDDB Act, my lord, their recourse is only available before the Debt Recovery Tribunal and not, my lord, before either the civil court or in arbitration. Now, my lord, in response to that, in anticipation of that point rather, the petitioner has relied on section 11 of the SARFAESI Act and a judgment of the Honorable Supreme Court. My lord, SARFAESI Act here is not directly applicable because this is not a secured loan. There is no security, so there cannot be any enforcement under the SARFAESI mechanism, my lord. They cannot go and take possession of any secured asset here. So, my lord, section 11 envisages that for crystallization of the amount due, before you can run to the Debt Recovery Tribunal for enforcement under section 9 of the section 13 of the SARFAESI Act, my lord, you can resort to arbitration. However, here, my lord, there is no security interest. So, my lord, that provision is not applicable. No section 21 notice issued, my lord, section 11 not filed, so they have not done anything since then. Look at my conduct, my lord. I have been diligent in repaying. These other transactions, my lord, are unrelated. And, my lord, whether there is any amount due, how much is due, this has to, my lord, receive the consideration of a different forum, my lord. This is my humble submission. It's not amenable to your lordship's kind jurisdiction. Oh, one more point ahead, my lord. I have placed, my lord, the RBI circular, the fair practice guidelines for NBFCs, my lord, which says that NBFCs have to carry out transactions, my lord, under express written loan agreements, which contain the following particulars, chiefly, my lord, the rate of interest that is chargeable. Now, my lord, this petition is filed before your lordship in the commercial division. My lord, section 21C1 of the commercial code says ordinary transactions of bankers, financiers, etc., my lord, relating to mercantile documents. Those satisfy the definition of commercial dispute and are amenable to the jurisdiction of this honorable court in its commercial division. My lord, my humble submission is, if they have, my lord, extended facilities without, my lord, any written loan agreement, which is required as per the RBI directive, my lord, this is not an ordinary transaction of a bank or financial institution. This does not therefore satisfy the definition of a commercial dispute and cannot be entertained by your lordship in the commercial division, at least, my lord. This is my humble submission also.
Take down.
What? Kindly allow me one moment, my lord. What are you saying?
Section 11. Said all of that. Yes, Malad, these are my suggestions. I'm great.
May I need to give a reply?
Yes.
Only one thing, my lord, I want to show in reply is that, my lord, before the same court, now they take a different stand. First of all, my lord, BNC says vendors and buyers, so I'm not going into that, my lord, that it is, my lord, can be anybody under the agreement. Just take, my lord, page 122 of the judgment or the order, my lord, which they have relied upon on the last day when lordship says show us another agreement. Just take page 122, but how this entire submission is wrong on his part, because today he makes a new submission under the same agreement.
Yes.
My lord, kindly takes, my lord, just last from the bottom, my lord, the last fifth last line. My lord, kindly sees. It has been stated in paragraph 5 that after restructuring, so restructuring means, my lord, under the same agreement, no oral agreement is argued. Further financial assistance was given to the respondents and fresh tranches were created in terms of the restructuring requested by the respondents. So under the same agreement. The disbursement dates have been mentioned at page 5. The loan agreement number is the same. It's the same loan agreement. The invoices have been mentioned along with the disbursement dates. Now, my lord, kindly sees which tally with the documents annexed by the respondent number 1 in the affidavit of opposition. Then next paragraph. Thus, the respondent number 1 has made out a case of restructuring of the loan account, if not a case of payment. So he has himself made out a case before this court only. This is restructuring of the same agreement.
May I just point out one thing from this order itself?
Just let him speak, let him speak, let him speak.
So now, my lord, kindly sees, my lord, I think, my lord, he's given his, my lord, defense. But anyway, this is his case. There is a clear admission of such restructuring of the petitioner's officer. The restructuring took place admittedly after the application under Section 9 had been filed. Since it was filed, my lord, these transactions have been made after the Section 9 was filed. Court said, my lord, cannot be taken account of in this Section 9. But, my lord, the agreement is the same. That's his case. Now he comes up before, my lord, to say that there is an oral agreement. Now, my lord, if there is an oral agreement, there has to be a pleading. And, my lord, oral agreement will also have a date. When, where, nothing at all. My lord, I am relying on his particular Reserve Bank guidelines only. I am following the guidelines. I have not transacted with him contrary to the guidelines that he has enclosed with the petition. I have transacted with a written agreement with him, my lord, under the agreement itself. And that judgment, my lord, is with regard to, my lord, lordship knows chloro control and all. That is with regard to, yes, my lord, that has got nothing to do here, my lord. So this is his case. This is restructuring.
I only wanted to indicate at page 120 of this order, my lord, my submission that, my lord, these subsequent disbursements that are made are also, my lord, not under this transaction or this specific document, my lord. That is also recorded. But, my lord, the Honorable Coordinate Bench was not required to go into this because from the petitioner's own documents, it showed that this is a closed tranche. Whatever has been disbursed to Vedanta stands repaid. So, my lord, the matter ended there. And, my lord, the Honorable Coordinate Bench has been pleased to record, my lord, or hold at page 123.
Yes.
Last 5 lines, my lord. The lender may also proceed according to, I beg your pardon, that is not it. A little before that, my lord, 4 lines before that, the arguments advanced by Mr. Banerjee are questions of trial before the learned arbitrator. So, my lord, these issues, whether these fresh disbursements form the subject matter of the same transaction, whether they are repaid or not, these are questions that have to be tried before.
No, that is perhaps, my lord, something, a statement which is very misleading. I must say that was not the subject matter in the earlier Section 9. That is a very far-fetched argument he's making.
My lord,
That
my
is
submission
the earlier transaction, not this.
I'm only making my submission, my lord. The judgment cannot be read as a statute, my lord. My submissions are recorded. The Honorable Court concluded the matter only on the basis of the petitioner's documents showing that, my lord, 2 crores disbursed to Vedanta stands repaid. Nothing more.
Correct.
I'm grateful, my lord.
If I start dictating, this will go on.
You can come back at 2 also, my lord, if your lordship wants, my lord.
Come back at 2.
Very well. We'll come.
Shall I make it reserved and
whatever lordship pleases, my lord, I have.
take time?
Whatever lordship pleases me.
Heard. We'll have it
Yes, yes.
Great.
Grateful.
Make it clear. We'll have it in a by tomorrow or
Yes, yes, my lord. No issues at all. Grateful.
the rest of the matters we can take after lunch. ये दो है ना।
Examination of judgment data. Supplement date is item number 1, EC-Com 449 of 2024, Tata Capital versus Ipanita Basu.
Yes. My client has surrendered before the sale.
Yes, yes.
যা বলবো সব সব মিথ্যা কথা না বলবো।
কি নাম আপনার?
কৌশিক বোস।
কৌশিক বোস।
For the plaintiff.
আপনার বাবার নাম?
আশিস নারায়ণ বোস।
বেঁচে আছেন?
না, মারা গেছে।
আশিস নারায়ণ বোস। আপনার বয়স?
আমার বয়স 72 তে জন্ম।
72 তে জন্ম, বয়স মানে?
বয়স
53
53
ইয়ার্স। বাড়ির ঠিকানা?
বাড়ির ঠিকানা সারদাপল্লী, গোলঘর,
সারদাপল্লী, গোলঘর,
বর্ধমান
বর্ধমান
713101।
713101। আপনি কি করেন?
আমি একটা ছোটখাটো ব্যবসা করি।
আপনাকে যেটি ব্যবসা বলবেন কিন্তু আপনি আসবেন, ঠিক আছে? আপনার উকিল বাবুর কাছে একটা ফর্ম আছে, ওটা হলফনামা। হলফনামাতে আপনাকে আপনার স্থাবর অস্থাবর যেটুকু যা সম্পত্তি আছে সেটা ওতে ফিল আপ করে জমা দেবেন। সেগুলো যদি না করেন জজ আপনাদের কাছে ঠিক আছে। The award data number 2 has surrendered before this court. He has been administered oath.
যেদিন ডেট থাকবে কোর্টে
Warrant of arrest is cancelled. The award data number 2 undertakes to file his affidavit of asset within a period of 2 weeks. Full stop. He further undertakes to appear before this court as and when required. Full stop. You file your
Yes, affidavit of asset.
affidavit of asset list after 4 weeks.
Within 2 weeks. My lord,
Within 2 weeks.
Deeply obliged.
Gratefully, Lordship.
Dada.
Matter
Deeply
after 4 weeks, sir. 26.
Commission of judgment data monthly title number 269, EC-Com 133 of 2025.
Lord, I'm appearing on behalf of the award debtor.
I'm appearing for the
Surrendering. যা বলবো সত্য বলবো, সত্য বলবো, মিথ্যা বলবো। কি নাম আপনার? অমিতাভ সাহা, বাবার নাম মানস কুমার সাহা। অমিতাভ সাহা, বাবার নাম মানস কুমার সাহা। বয়স? আমার বয়স হচ্ছে 46 প্লাস। 46। বাড়ির ঠিকানা? বাড়ির ঠিকানা 39 NS Avenue। 39 NS Avenue। হ্যাঁ। শ্রীরামপুর, হুগলি। দিন কত? 512-201। 512-201 করেন আপনি? আমি ছোট ব্যবসা করি। আপনাকে যে কি দশটায় বলবেন আসতে কিন্তু আসবে। আচ্ছা, ঠিক আছে। তার উকিল বাবুর কাছে একটা ফর্ম আছে, ওটা হলফনামা। আচ্ছা, ওটাতে আপনার সম্পত্তি আছে, স্থাবর অস্থাবর যে সম্পত্তি আছে। যদি না করেন আপনাদের একটু দশটায় স্টেপ নেবেন।
Why don't you make the payment?
পয়সা দিচ্ছেন না কেন? স্যার, আমার একটু প্রবলেম চলছে, বিজনেসটা অফ হয়ে গেছে।
Still you have to make the payment, otherwise I'll go to jail.
পয়সা না দিলে তো my lord, I have spoken to him, my lord. We'll see that this matter is settled, my lord. Settlemented দিকে যেতে।
Same order. Award data number 2. Surrendered. Warrant cancelled. File your affidavit of asset within 2 weeks.
My lord, 3 weeks.
3 weeks. List after 4. Same day. Same. 26 February.
My lord, I suppose when the warrant was also issued against the wife.
Cancelled.
My lord, both
Against?
against the petitioner and his wife, my lord.
Wife?
No,
There's no warrant.
Wife.
No
I was
warrant.
informed by him, but grateful, my lord.
Daily list item number 14, commercial division. 14.
Your Lordship, I am for the petitioner. On the last occasion, there was a talk of settlement was going, but still there is a pending and there is not finalized by the settlement. So kindly keep it after 1 week.
Learned counsel for the petitioner states that they are still exploring the possibility of an amicable settlement. She prays for an adjournment. Let this matter be listed on 23rd February.
My lord, I am for the petition. I am led by Mr. Owen Banerjee. He is just on his way, just praying for a very short pass.
This matter I required to take instructions on last date. This matter was copy was served, my lord. I appear on behalf of the railways, my lord. Initially, they have filed an application relating to the same matter for appointment of arbitrator, my lord. Subsequently, they have filed the second application, my lord, for not cancelling the agreement, my lord, restraining the railways, my lord. So I need to take instruction with regard to that. 7 days time may kindly be given.
My lord, in the section 11 matter, it came up today, but none appear for the railways.
I'm sorry, my lord. I missed. I'll take up that matter, my lord, because I require.
My lord, in the meantime, no coercive steps may not
No
be.
coercive, nothing doing. Land, I'm not going to stay any.
2017, this
No question.
agreement has expired, my lord. This.
No question. No question. Next week. Not today. Next week.
Next week, my lord.
And you see if you can mention the matter and get the arbitrator appointed.
But that is, I'll see to it.
Not this week. Not this week.
16.
But in this matter, your lordship had passed a ex parte order. On the next returnable date, my lord, the respondent had not appeared. Your lordship had asked me to serve afresh. My lord, we've served them. My lord, it's been received not both by mail and by by post. My lord. We registered post. Give me a copy. Yeah.
You move your section 11.
Yes,
Get the
we'll
arbitrator appointed.
do that. We'll do that after this.
In the meanwhile, I'll extend it.
My lord, the interim order may be extended. Your lordship may direct affidavits to be filed by them. Lord, I'll communicate the directions to them. Lord. Since they've not come, Lord, the interim order can perhaps be not extended till disposal of the application.
Not till the disposal of the
I
application.
leave it.
You will never get the application
I leave
disposed
it
of, Mr. Vachava. This
Lord.
is the practice.
No, my lord, I leave it to your lordship. Lord, we have served them. They don't seem to be interested. Your lordship will remember it's a secured date.
Yes, I do remember.
So,
Even in NCLT, they are trying to delay the
problem is,
in that case, may I, my lord, request that your lordship grants them time to file the affidavit peremptorily. Lord, it's appeared twice now after
them appear
notice.
whether they want to file it, they don't want to file it. How do you know? All of them have served.
Yes. Active party. There's only one respondent.
Only one respondent. Aviral. Affidavit service taken on record. Despite service, none appears for the respondent. Last time also similar order was passed 13
Yes,
January.
madam. Yes, madam. We got it to the. What is this here?
What had happened on the last date, 20th?
But on the last date also we had served. We could show that it had been served by mail,
Right.
and the post had been received 1 day earlier. So your lordship said, well, let's give them a little time, Lord.
Interim order is expiring on?
But it expires today, Lord.
Interim order granted earlier is extended further for a period of 3 weeks. List after 2 weeks. We'll see. Let them come.
But may I suggest something, Lord? please permit them to file the affidavit if they choose within 2 weeks. Otherwise, my lord, they'll come and ask for affidavits again. It'll just delay it further. That's all, my lord. I leave it to your lordship.
But that they will only delay it. It doesn't really harm you.
No, no, it doesn't. It doesn't. I was not suggesting it for the.
Let's see what they have to say.
No difficulty.
In the meantime, at least you file your section 11 so that arbitrator
We'll do
is
that.
appointed. What's
We'll
the
do
point of?
We'll do that. Oblige.
But I appear for the petitioner, my lord.
Yes.
Not similar difficulty, my lord, in the morning.
Yes.
My lord, the service is not complete. Respondent is avoiding services, my lord. Will kindly permit me, my lord, 2 weeks, and also, my lord, grants me leave
Which
to
was
file.
the earlier matter item?
Serial number 5.
Same as item 5.
But here, my lord, 3 respondents have been served. 1 respondent have not been served. I'm just praying for 10 days. My lord, kindly keeps any
Who
day.
has not been served?
My lord, will kindly say, my lord, Ankit Singh, which is the, my lord, respondent number 4.
To the dictation. Respond number?
4.
Let's change. Learned counsel for the petitioner states that seeks and is granted further time of 2 weeks to serve upon respond number 4. Let this matter be listed.
Well, kindly grants me an early date if your lordship permits.
Same as the other one. Very good.
Great.
Now 18.
This is my section 9 application. I was praying for an interim order. I made my submissions. Mr. Shaha was to start his submissions.
I was representing respondents 13 to my lord 16.
Your Lordship, Mr. Shah is on his Mr. Shah is on his leg for court number 25 at the moment. A short passover may be granted.
He'll have it tomorrow.
Only thing, my lord, if I'm not there tomorrow, my lord, then kindly for my reply, kindly keeps it on Monday, my lord, in that
Keep
case.
it on Monday then. Let's.
Because I think Mr. Shah will take some time. Let him do it tomorrow, my lord. Let him complete, my lord. Mr. Shah will take some time, my lord. I've shown few judgments, so he'll take some time.
Tomorrow is.
And then, my lord, I think Mr. Dotto will also make submission.
Yes, I am.
So let them finish it this week, my lord. I have no issues.
I can start if. Otherwise, my lord, since I would be echoing, my lord, a lot of.
Not today, tomorrow.
Yes, let them continue. Grateful.
My section 9 application, my lord. I appear for the respondent. I'm opposing the section 9.
But this section 9 application arises out of a work order which was issued in favor of the petitioner. The value of the work order is approximately, with taxes, 23 crores. My lord, in terms of the work order, I was to supply certain machineries which I had to build specifically for the respondents. This marketability, I do not have any other person to sell those machineries because these are designed and manufactured and prepared only for the respondents' usage. But the first work order was of 10th of June 2023, which is at page 29. My lord, if your lordship kindly comes to page 30, lordship will find the value of the work order. It's 20 crores, 20 lakhs. That is without taxes. With taxes, it approximately comes around to 23 crores, 83 lakhs. Lordship will find the payment term is also mentioned over there. But this payment term subsequently has been modified. The last of such amended work order is at page 63. If your lordship kindly comes to page 63 for once.
Page
63. But today I'm asking for a security or an injunction on the assets as an interim of prayer, my lord. The Lordship will kindly take this. This is a final payment term, which is at page 63. 30% of the contract price as non-refundable advance payment against down payment, pro forma invoice, and payable within 7 days after submission of necessary documents. So first they will have to put, I will put in the documents, they will pay 30%. Once they pay the 30%, the obligation will come upon me to supply. Only after that, they will have to put in another 50% before delivery. The next clause is that 50% of the contract price along with 100% of the applicable taxes, duties, levies, etc. on a pro rata basis prior to delivery against submission of the pro forma invoices. Lordship will kindly come to page 66. That the effective date of the contract. Lordship will kindly see clause 4, effective date of the contract. This contract order shall become effective from the date on which the following prerequisites are fulfilled. One is receipt of the down payment, and 2 is opening and operability of a letter of credit. Two things, two conditions have to be fulfilled. Well, pursuant to this 30%, they make a payment of around 6 crores rupees to me. I get the goods organized. I get the machineries, make everything, and it's ready for delivery. Rest 50% does not come in. Several communications are there on record where they have themselves accepted that we are facing difficulties. After 30%, they will have to put in the rest 50%, and they will have to open an LC, letter of credit, which is the requisite of clause 4. When we write to them saying that kindly take the machinery, they say that we have terminated the contract. Refund us the 6 crore rupees that we have paid. But kindly consider the situation today. Once they make the payment of 30%, and these are machineries which are of specific designs, specific size. It has got no other marketability. I cannot sell it in the open market. This will have to be sold as per the specification to the respondent. Now they are not paying and neither taking the thing. But there is around 14 crore rupees due today. But I am requesting, let them disclose what are the assets they have. Until that point of time, let them not deal with those assets. It's an admitted position that the contract is valued at more than 20 crores. With taxes, it's something 20 or 23 crores. They have only paid 6 crores rupees, which I have utilized for manufacture and construction of the machineries, which they were supposed to take after putting in 50% of the remaining sum of money. The effective terms says that 50% they are going to pay, then I'm going to deliver the product. But these machineries have to be made. When they pay 30%, I get the machineries made. Rest 50% they don't put in, and they're not taking. Lordship will kindly take one of the correspondences at page 62. This is prior to this modification of the terms. Annexure G, my lord, page 62. Thank you for your email and sharing the details regarding the materials and the challenges you are facing due to delay in payment disbursement. We have noted that the proposed date, however, due to the prior commitments of our MD sir schedule, he is unable to meet on the suggested date. As per his availability, we would like to propose a meeting on 24th of September 2024. Well, it's an admitted position. They are in financial crunch. They couldn't make payment. And they admit the fact that I will be in difficulty because I will have to put in that extra money from my pocket to manufacture those machineries. But that is the reason, since they were in difficulty, the work order was amended. The amendment which I placed is at page 63. But the invoices starts from page 68 to 90.
Wait a minute. You are supplying the equipment.
I am supplying the equipment.
What are the terms? The first, page 29.
First is at page 29, your lordship.
Order is placed by them.
Order is placed by them, my lord.
On 9/6/2023.
9/6/2023. But 10/6/2023. It is the date.
What are the terms?
Well, the terms are. Huh?
What are the delivery times?
Well, delivery time is 9 to 10 months. Well, kindly comes to page 30. The clause number 1, the delivery time.
Page
30, 30, Your Lordship.
Yes, 9 to 10 months, right?
9 to 10 months. For
Right.
side basis on the effective date of the contract. I have showed Lordship that the effective date of the contract will be the date they make the payment of the first 30%, and they put in the LC.
I'm not following you. You have the equipment is supposed to be.
I have to supply the equipment.
You have to supply the equipment.
I have to supply the equipment. This equipment have to be manufactured.
Right.
First, they will put in 30% of the money after
Right.
me putting in relevant documents.
Right. Payment
Once
terms, clause 3, page 31.
Page 31. Now, this clause was subsequently modified. This payment term was subsequently modified. The last of such modification is at page 63.
Page 63. With reference to the work order and the subsequent amendment.
So you will kindly see 30% of the contract price as non-refundable advance payment. It is non-refundable. So you will kindly keep against down payment pro forma invoices and payable within 7 days after submission of necessary documents.
So they have paid
30%. They've paid 30%. I have made the machineries. I've got the goods ready. I put it this way. I've got the goods ready. They'll have to put in rest 50% and open an LC. That is clause 4 at page 66.
When did they make the 30% payment? What is the delay on your part?
But there is no delay on my part. I'm ready with the thing. They are not making the payment and not taking the machinery. There is no delay on my part. Machineries are ready. We have written several communications. Take the machinery. I am being charged for storage. I have been the suppliers are asking for escalated prices. No, nothing. They said I'm terminating the contract. Give me back my 6 crores rupees.
All right.
Well, I'm late.
Yes, Mr. Mayor.
You would not want to leave. Well, the issue is two. If I look at the Sale of Goods Act, once the goods are ready for delivery, I have an obligation to inform my buyer that the goods are ready for delivery. The buyer thereafter has an obligation to come and collect the goods. Here, the contract, as Mr. Gora has already shown to your Lordship, the contract has taken effect. 30% out of 20 crores I have received. Now, once I get the 6 crores, I have the goods which I have to now deliver. That amendment is not very important. The time schedule, the payment time gets extended. Finally, when that extension happens, 6 days from then, they write a letter to me saying, I'm terminating the contract. This is not working out for me. By then, I have procured goods and those invoices are disclosed in my section 9 worth about 14 crores. I have received payment of about 6 crores. There's a specific pleading in paragraph 48 of my application that these goods are unique to the respondent. So in aid to mitigate, I will not be able to go ahead and sell it. So I have come in the reference, I will have a claim for money, claim for damages. Whether mitigation is possible or not, that will also become an issue in the reference. Now, as of today, I have asked for a security on attachment. Attachment, I'm aware of the law that they will have to be given a chance to show cause as to why attachment should not happen. My prayer before your Lordship today is let there be an injunction on them from operating the bank account to the extent as I have claimed. And in the affidavit that they wish to file, if they do, let them disclose the assets that they have. In aid of this, may I just cite very oft-cited decision of the Supreme Court? Now, this is 2021 6 Supreme Court cases 418. So there's certain guidelines which are there, if your lordship could just consider that. (42) onwards, kindly have a look at.
But can you force them to buy the product?
No, no, I can't force them to buy the product.
Then what is the loss? Then you have to prove your loss.
So the moment, Lord,
How can you
once
seek
the goods,
injunction?
so these sale of goods by specification.
Yes.
Once the goods are procured by me or are ready by me in terms of the agreement, and I inform them of taking delivery, they don't take delivery. Then the title to the goods don't pass.
Yeah,
I'm entitled to the money.
Mr. Banerjee, I'm only looking at section 9. You have
Yes,
to make a proper
I am also indicating from the perspective of section 9. Just giving a brief background on fact that there is a buyer and a seller. The seller has the goods ready. Post notice to the buyer has not taken delivery of these goods. Now, what are the rights that this seller has? Here, the title has not passed because the goods are lying with me. They haven't taken delivery as yet. So, I will have a claim for damages. I will have a claim for damages here.
Only if you can prove it.
Only if I can prove it. But I have before your lordship today. So, what is the test that the court is now required to? Section 9 court will see that I will have a claim for money in reference. What is to be done with this money, primarily in view of the fact of the letter that was just shown to your lordship at page 62. Their inability to make payment is an undisputed position today. So what is it that I can ask for the court to preserve till the reference actually happens and I'm before the arbitrator, either by way of a 17 then or once, whichever way I want to take it up. What is it that the court secures? If it's a 39-1-2, what is it that the court secures? That, if your lordship looks at paragraph 42.1 of this judgment 1. Paragraph 42. I am not, my lord, I'm conscious of the position in law that I can't ask the court to decide these issues today. It will be unfair on the tribunal, unfair on both the parties. Paragraph 40. All courts dealing with suits and execution proceedings shall mandatorily follow the below mentioned directions. In suits relating to delivery of possession, the not relevant. (42.6) kindly see. In a money suit, the court must invariably resort to Order 21, Rule 11, ensuring immediate execution of decree for payment of money on oral application. In a suit for payment of money, before settlement of issues, the defendant may be required to disclose his assets on oath to the extent that he is being made liable in a suit. The court may further, at any stage in appropriate cases during the pendency of suit, using powers under 151, demand security to ensure satisfaction of any decree. That's one of my prayers that I have. I am at this stage asking for a lesser relief before the court because I'm at an ad interim stage. I'm saying let them disclose the assets, whatever they have, along with the affidavit if they wish to file one. Till then, let there be an injunction restraining them from operating the bank account to the extent of money that I will have a claim for in the reference, and that's quantified here.
Mr. Banerjee, I think you have already assumed everything for yourself. That the award is in your favor, the execution.
No, my lord.
Execution has
No,
been filed,
there is no such
affidavit of
assumption.
asset should be filed.
No, if your lordship sees 42.7,
protected.
42.7
Sorry,
is in a suit for payment of money. My lord, in every suit that we come up and we ask for an injunction on the bank account, the decree is awaited. In every suit that your lordship grant attachment or your lordship grant an injunction on the bank account, the decree is awaited. It's at an interlocutory stage. So what does the court see when it grants this interlocutory order? It weighs out the balance. And I am showing from page 62, 4 things I'm being able to show. There is a contract between the parties. Under the contract, as a seller, I have obligation to deliver the goods they have an obligation to take it and make payment. 3, it is before the court today that these goods are ready. Notice of delivery has been given. These goods have not been taken by them. And although the contract stands extended, this has stood terminated by them contrary to the contract. So these 4 facts I'm being able to show before the court at the prima facie stage, at an ad interim stage. And if without, and I can't lose sight of the fact that at this stage, my pleadings are to be taken to be true and correct. I'm also showing from page 62, their inability to make payment is writ large from that document. If your lordship comes back to page 62 once, it's an undisputed position that they're not in a position to make payment. As on September 17, 2024. Post that, there are several correspondence, several invoices where I've said the goods are ready, please come and take delivery. So the price of the goods is what I will be entitled to in law. Here, their failure to take delivery, well, this will not be a suit for price.
Yes.
But this is a case, Lord, where I am showing that this would, if it had been a suit, it would have been a money suit. And 42.7, your lordship has seen, it refers to a suit in a money suit awaiting decree. For your lordship's convenience, if I may just place it, in a suit for payment of money, before settlement of issues, the defendant may be required to disclose, and these are guidelines which the Supreme Court has held. These are mandatory, required to be followed.
Yes.
So at least at this stage, your lordship will consider this, that when they file their affidavit, let them disclose the assets that they have. This much your lordship will kindly consider at the ad interim stage. After, if they want to file an affidavit and come, that's up to them. And this much let them do. Your lordship will kindly consider that they'll disclose in their affidavit, they'll disclose what assets they have. So I am at least protected to the extent of the claim that I have, primarily in view of page 62. Well, these are my respectful summaries.
Yes.
But I just checked up one thing which could have potentially been, my lord, another disaster for me while opposing injunction petitions. Whether the money, my lord, which I have paid him is less than the value of the goods supplied by him. Because all of it would have gone if, say, for example, I had given him, my lord, 6.5 crores and he had given me goods worth 10 crores. In that case, I am well aware that I would have suffered an injunction to the extent of 3.5 crores. Without it, if I could have shown quality issues, I would have got through. Contemporaneously indicated serious quality issues, I would have got through. Otherwise, you accept goods and sit on it, there's no scope. I know my fate. But I found, my lord, in this case, it's absolutely, it's absolutely, my lord, the same. Value of goods and advance payment. So the contract was, my lord, that, my lord, please have a look at page 120. 126. This is his calculation. 126. Thank you. The fifth column is total invoice value. 99120,000. This is goods which I have got, invoices which have been raised. And your lordship would now see the next column, payment received, refund to client, then, my lord, net payment received. 91840, such and such. more or less the same. We don't, this is, my lord, an enclosure to his invocation notice. Previous page, my lord, is the invocation. Lordship would, my lord, please see the invocation notice. So, my lord, there is parity between the value of the goods supplied and the payments made. Now, my lord, he says that I am in breach by not accepting the goods. I say that he is in breach by not following the terms of the contract. Just two documents I want your lordship to see. Number one is, my lord, the original contract, which is, my lord, page 29. My lord, please come to delivery time, which is at page 30. The equipment delivery time for the scope as specified in the technical offer is currently 9 to 10 months FOR side basis. Then, my lord, extension of delivery period is possible. Payment terms, my lord, kindly see 3.0. 30% of the contract price against down payment pro forma invoice payable within 14 days after submission of document, 70% of contract price with 100% of taxes, etc. Contract, my lord, starts with disputes. Ultimately, the dispute gets resolved and page 41 is issued, which is, my lord, an amendment to the contract. Now, performance guarantee will be binding to completion of supply of equipment will be 9 months from the payment of advance.
Yes.
Yes, below that clause 3 payment terms. Clause 1 below at page 43 delivery time 9 months for side basis. Then clause 3 payment terms 30% of contract price as non-refundable advance payment against down payment. Now, my lord, is important. Pro forma invoice and payable within 70 days after submission of necessary documents. Then 60% of contract price along with 100% of taxes and taxes, duties, levies on pro rata basis prior to delivery. So, my lord, 30% is the payment terms, 100%, 60% of contract price with taxes, etc., on pro rata basis prior to delivery. Payment is to be covered by an LC, etc., etc., opened within 30 days of billing breakup, etc. Now, my lord, I give him, after this, I give him, my lord, 6 crore odd, which is the 30%. There's no breach there. Earlier, whatever has happened, there are disputes. He says, I'm in breach. I say he's in breach. Ultimately, all of it is irrelevant because parties agreed, amended, extended the time 9 months, and this is the payment schedule. In terms of this, I give him 30%. Now he has to give me the entire goods and raise the pro forma invoice saying I'm giving you the entire goods. I'll pay him 60%. He'll give me the goods. This is what is agreed. He doesn't give me the entire goods. He gives me part. This I say is his breach because I needed the goods. So I terminate the contract.
Where is it? It's reflected where?
This is, my lord, page 104. 104 is the and my lord, subject to issuance of PO, my learned friend is correct. I should have shown page 63 also. This is, my lord, the second amendment to the purchase order. First amendment I showed your lordship. Second amendment is even clearer. Please see, my lord, page 63. First amendment was page 41. This is something I missed. With reference to work order and subsequent amendment, we would like to propose the amendments to the payment terms under clause 3 as follows. 30% of the contract price as non-refundable advance payment against down payment pro forma invoice payable within 7 days after submission of documents. Then 50% of the contract price along with 100% taxes, etc. on pro rata basis prior to delivery against submission of pro forma invoice. This pro forma he doesn't give me for 100%. So, my lord, I ultimately end up terminating. And whatever, my lord, goods he has given me, I've paid for it. I've paid around 9 crore something. The difference is, I think, it's a few lakhs. So this is not a section. And for damages, there can't be, my lord, attachment. My lord, there are some judgments. My lord, there are 3 judgments of this honorable court, all by Justice Sanjeev Banerjee, which says, my lord, as your lordship observed in the course of this hearing, same thing. First, you have to prove loss, and then you have to prove quantification. So at this stage, in a damage, that's the difference between a damages claim and a quantified claim. So there is no scope of, my lord, any injunction. There are 2 Delhi High Court judgments also. I think I'm carrying one. The others are on the iPad. But perhaps it's not really necessary. And then the termination notice. Lord, please have a look at the termination notice at page 104. This, my lord, is telltale. Now, after the contract is terminated, suddenly he says, everything is ready, everything is ready. My lordship is at 104. My lord, please come to 105.
Yes.
Paragraph 10.
That's what I'm reading.
Yes. Pertinent to state, letter dated such and such, Hazelmac confirmed receipt of advance payment. Therefore, as per terms of purchase order with amendments, evidently the delivery period was valid till 30th September 24, considering advance payment was made on 30th December 23, which is the later event qua delivery period post entering into the agreement. Further, as per the contractual norms, supplier did not invoke extension of delivery period. Contract came to an end on 30th September. SSB Energy was discharged from obligation. Then, at this juncture, after lapse of 5 months from the date of expiry of delivery schedule, expression of your readiness to supply machinery and equipment is unfounded. Delivery period came to an end on 30th September. SSAB Energy is not inclined to take delivery. We right to recover advance payment of such and such. Hazelmac has failed to deliver machinery within the delivery period. Delivery period contract came to an end. Is not obliged to take delivery. Advance payment of 6.07 crores should be refunded because part machinery is of no use to us.
Yes.
Then this is, my lord, also March 25. Then on 22nd May 25, there was a meeting which was held. Your lordship would see, my lord, page 112. He wanted to resolve the matter. Second paragraph. That said, his letter, that said, we believe it is crucial to meet and discuss the matter further to attempt to amicable resolution. Such and such. We propose a meeting, page 113, at Kolkata or Bhubaneswar in March 25. Then that meeting, my lord, did not help. It failed. Meeting was actually held on 22nd May 2025. Meeting was held. Then July 2025, he invokes arbitration. August 25, I reply to invocation notice, and this petition is subsequently filed. I'll just indicate the in December 25. Now that itself disentitles him to any interim relief. Having
Yes.
so this is, my lord, the situation. Now, my lord, I've shown your lordship. Firstly, I've given him an advance of around 9 crores total. I'm entitled to refund. I'll have claims in damages against him because he failed to deliver within the time. Alternatively, even if I assume that the part delivery I'll have to show in arbitration that his part delivery was A, useless to me, B, mitigation. If I fail, then my claim goes. But if I succeed, I'll get my full money back with damages. I must have, my lord, spent more money to buy the same goods. But assuming all of this is forgotten,
Yes.
whatever part delivery he has done, I have paid for it. It's more or less the same. So that he can't, my lord, have any claim against me today. Claim in, my lord, damages cannot be secured. My lord, one judgment, I'll just hand up.
Copy down, Dada.
দিয়ে দিচ্ছি দাঁড়া হ্যাঁ না নে Lord, paragraph 27 and 28. Lord, Gatix, likewise, even in Gatix, a distinction was drawn by the court itself between speculative and non-speculative claims, and the interim direction was granted only in respect of liabilities that could be determined. Therefore, neither of the above decisions support HCCL. In the present case, an analysis of the claims of HCCL reveals that a substantial part of the claims is for loss sustained by it on account of the suspension of the contract. In other words, a substantive portion of the claim is only in relation to speculative losses which are not quantified and in respect of which no sum can be determined till after the evidence is led by the parties. Then, my lord, last sentence. ET itself had not applied its mind to the distinction between the substantive claims which are speculative in nature and those which are not. Therefore, impugned order is erroneous.
Get an arbitrator appointed, get the issue decided.
Yes.
Thing is
But
there.
just two.
My lord, I am ready
But
for
couple of-
appointment.
But that's
Anybody your lordship
take
feels.
instruction, my lord, on that. But let's
Take instruction. Come
Lord.
back tomorrow. I'm not inclined.
but a couple of things will come back.
Lord, I was reminding Mr. Banerjee.
Not inclined at all.
I'll come
Take
back tomorrow.
instruction. You want me to pass an order, I'll pass an order, but I'm not. Come back tomorrow.
The claim will not be too heavy.
Tomorrow?
Yes, yes. No, claim will not be too heavy. We can agree to.
Reach out.
Grateful.
Tomorrow.
Apply.
I'm just keeping it not today, Mr. Chaudhary.
Yes, yes.
tomorrow. I've heard you.
But Lordship will give me if 5 more
I will
minutes to
give
reply to Mr. Chaudhary if required.
Give you 10 minutes. Outcome will be the same.
Yes, yes.
To my satisfaction.
I can certify that.
To my
Sometimes the
satisfaction.
client says, please try, which is why we try. But as counsel, we know when it's crossed the no turning back point.
Unless until you do some magic.
Let me try, my lord. Obliged.
Not non-commercial.
Matter first time. Non-commercial matter. I number one.
Well, this is my application. This is an application for contempt of your lordship's order.
Yes.
Well, the order starts from page 14. Oh, sorry, my lord, it is page 15. 14 is the affidavit page 15.
Yes.
Your lordship was pleased to direct them to decide the issue within a period of 6 weeks from the date of communication of the order. Now, my lord,
This is appearing for the first time. Let a copy be served upon me. And one thing I would like to point out, Lordship, Rakhi Ganguly has transferred from this department in 2011. It will be Shudip Bhattacharya. And I have got instruction that order has already been passed.
my lord, your lordship kindly see that my client has been called for hearing, page 21.
Whatever it is, that
Called
can
for
always
hearing.
Order has already been
My
passed,
Nandi
Lordship.
Junior waited for 1.5 hours. The assessor collector was not present. And his PA informed my learned junior that today hearing will not be done. Later on, the communication will be made to you.
Finish it off.
And thereafter, nothing has been done.
Order has already been passed, Lordship. I have got the copy of the order.
Without hearing. Without hearing. And we have given notice to them on 11th, page 19. Your lordship kindly see, 11th of November. That please hear the matter, otherwise contempt application will be filed.
Just check it out. The petitioner has filed the present contempt petition, alleging willful and deliberate disobedience on part of the respondent in failing to comply with the order dated 7th August 2025 passed by this court. Full stop. Learned counsel for the respondent seeks and is granted 4 weeks time.
Lordship.
4 weeks time to file compliance affidavit. List on बाकी matters कब रखा है वो keep it on.
Can the cost schedule be changed because Rakhi Ganguly has transferred from this department?
I will. On 23rd. Full stop. Learned counsel for the respondent further points out that the respondent, Srimati Rakhi Ganguly, the assessor collector, North Calcutta Municipal Corporation, has been transferred. And that
Shudip
Bhattacharya has assumed the office. Full stop. Let the petitioner undertake the necessary amendment in the cause title and implead Sudip Bhattacharya as a necessary party to the present dispute. The same shall be carried out within a period of 1 week. List 1 week. List after 4 weeks. Give a date on 23rd of February. 23rd?
I'm grateful, my lord.
See how the order has been
Lordship,
passed.
I have been forwarded with the notice and attendance sheet where it appears that she appeared in the hearing, Lordship.
Yes, she appeared on 15/9. Hearing has not been done. The department করবে তো জীবনে নামাতে হবে তো
আচ্ছা
Do you appear for the private respondent number 6?
no for petitioner
On the date of hearing 15 September, only the learned advocate for and behalf of the petitioner, Kakli Datta, was present.
yes
No hearing was
no hearing was
that
taken
day
place.
উনি অন্য জায়গায় গেছিল he was not
The assessor collector was not present. And you will also kindly see when the order was passed. And even if the order has been passed, no copy has been served on us.
হিয়ারিংই হয়নি তো ওদেরকে যদি ওরা বলে হিয়ারিং এর দিন আমরা প্রেজেন্ট ছিলাম
লিখেছে তো present.
প্রেজেন্ট ছিলাম তো সেগুলো করা হয়েছিল কিন্তু উনি ছিলেন না উনি অন্য জায়গায় ওনার ইয়ে ছিল মিটিং ছিল
নামটা লিখে রেখেছো সুদীপ ভট্টাচার্য
হ্যাঁ উনি অন্য জায়গায় গেছিল
Yeah, filed a reply also there.
তাই তো আমরা
reply yes we have filed our written argument there.
Yes, they have taken all that into consideration. Challenge the order if you are aggrieved by.
But your lordship was pleased to direct them to hear us.
Sir,
we are present there.
You were present there. This records I'm not there. This records that you have been heard, representation has been considered, and then order has been passed. I can't go and sit in the office of the assessor collector, right?
I am not asking for that.
So I am going by whatever has been passed.
If they written something which is not correct,
sir, either you challenge this order, whatever the order is, the order has been complied with.
Because the hearing.
You file this with your compliance affidavit.
Lordship, they forwarded the attendance sheet also.
Yes. We'll consider.
Meeting notes টা আগেই দিয়ে গেছিলেন আপনি
File a compliance affidavit.
Lordship.
Amendment within 2 weeks.
Along with the server proceeding.
By the they'll do it.
Okay.
Lordship, Miss Saheli Vishwas is appearing in this matter. She is not keeping mail. Lordship, I'm praying for not this week.
Not this week.
My lord, I am appearing on behalf of the award holder responding. I am leading by Mr. Siddhartha Banerjee, my lord.
The 34, what is it? Yes, Mr.
Stuck with the jam outside, my lord. This is section 34, my lord. Compilation টা কোথায়? Well, the arbitration arose from an infrastructure development agreement between the parties. The claimant filed the statement of claim for diverse claims.
What is of which year?
This is of
2018.
2018.
5th January.
5th January 2018. That's what.
260.
Huh?
260.
The award is at page 260
My petition.
of the petition.
260,
my lord.
Yes.
বলে তো আমার কলমটা নিয়ে আসতে, কলমটা ফেলে এসেছি আমি। If you also kindly see, Malad, may I just shorten the entire thing? Malad, there's one claim only which was granted. The claim was with regard to certain anti-termite works. So the dispute was, Malad, two-pronged, Malad. One was, Malad, the contractor had to first get all bills, Malad, certified by the engineer. Admittedly, there were no certified bills with respect to the anti-termite works. Second, Malad, was that according to the respondent, that's the employer, there was the requirement of making or doing the anti-termite work was recalled. And the other parties, Malad, they have relied on certain bills which are all Malad, not been proved. And these are the only bills which they have referred to, and on that basis, Malad, the award was passed. So, Your Lordship, I will straight away take Your Lordship, if Your Lordship permits me, to the portion of the anti-termite works where the learned judge, the learned arbitrator has dealt with it. Now, Malad,
Internal page 35. Decision.
Malad will kindly come to page 35 of the award, Malad. First may start from 16, Malad, sorry. I will kindly see claim for anti-termite works. Well, this will be running page, Malad. This wouldn't be a running page because it's a certified
Award.
Award, Malad, 16, Malad.
Page 16. Claim for anti-term.
Malad. C, D, and E of the statement of claim. Claim on account of anti-termite work in terms of item number 5, 6, and 7 of the work order which is carried out until November is also reflected in the minutes of a meeting of November 1st, 2007. And the fact that anti-termite work has been duly carried out by the claimant would appear from the serial number 6 of the said MOM. I'll take Your Lordship to that, Malad. I'll just place this first. In the minutes of the meeting of April 2nd, that's the original AP. Compilation. Original AP, section 30. Malad, there's some problem with the pagination. We have given you a compilation of documents, and other than that, there's a main AP. Main section 34.
I have only one copy, Millard, maybe fault on my part. Millard, at my end. Millard, I need to check the page numbers with my learned friend because the page numbers are not telling at all.
No, but do you have the award?
It is there, but on a different page.
Award also?
Yes.
How can award, the internal page of the award, how can that change?
No, Millard, the internal page of the award is Millard telling. Internal pages are telling.
So
the running page numbers
the running
are
page is not there.
No.
He's saying he doesn't have the brief, basically.
No, I have it, Millard, as soft.
Separate
It's
document.
a separate bunch altogether.
That's only made for you. We don't have the privilege of having that separate document.
I don't have the privilege of having the main section 34 application.
But it appears that I have made a compilation of documents only for convenience, which have served much late. 34 was in 2018. For some reason, it appears that they don't have the document in section 34. So, that
There lies the difficulty.
This is only later on where he had actually.
I had come before Lordship said, let's not bring in all the documents, only the
Originating 34 application is not there with me. I have only the compilation, which is why Millard, I will a little bit confused. Maybe let's once sit with my learned friend on the other side, get a copy and come back to you.
So let him argue today.
Wait.
Not 2018. I mean,
True. And I would like to use an opposition also. Should I use this?
No way. 34 what? We will stop this practice.
Wait.
I am not going to.
I follow, Millard. I agree.
I am not going to. I mean, Even some lawyers suggest that please record that, none of the contentions are admitted and blah. What are we doing in 34?
Absolutely.
What practice is this?
But all the documents before the arbitrator should be before your lordships.
If at all you want to file something, file a compilation set where all the documents are placed on record, whatsoever was before the tribunal. But not beyond that. I mean,
No
we are not
difficulty.
starting new pleadings here.
No difficulty.
Yes.
So, my lord, I was at paragraph 21, my lord.
21.
The amended work order dated 26 June 2018 had retained the provisions relating to anti-termite work, as is evident from item numbers 5, 6, and 7. Work has been started and carried out with the claimant since the issuance of the work order on 9th May 2007. Then the respondent has not denied in the exhibit CI or CO or CP about the claimant having carried out the anti-termite work till November 2007. There is a specific denial. I'll refer to that in the statement of defense, my lord.
What is the period, the contract period from when to when?
Well, this contract period, my lord, that should kindly come to the contract.
Because if they are admitting it till
page 1, sorry, my lord.
If they are admitting it till 2007, then it must be running prior to 2007 and subsequently.
It's from 2007, but it kindly takes page 198, my lord.
Yes.
What period?
198, 22nd November 2007.
That's.
This is
This
22nd.
is the work order, my lord. First work order. Can you see on the top confirmatory work order? He doesn't have it. Why are you doing it? So, my lord, the work order was of 22nd November 2007.
The description of work does not carry the word anti-termite treatment.
My lord, in this one, it wouldn't, but my lord, may I just show the, if your lordship kindly comes to page 206, well, I must show the records. So 206, if your lordship kindly takes, annexure 1, excuse me, to the work order, and it is there at serial number 5 and 6.
This is part of the contract, annexure 1.
Yes, yes, my lord.
Where is it mentioned? Annexure 1.
And annexure 1 is there, but I'll just mention them.
A.
Yes, my lord. Huh? Serial numbers, clause number
1A is annexure 1.
Annexure 1.
6.
That contains my lord, serial numbers 5 and 6.
All right. So you're saying that.
Yes, but I cannot go away from the work order.
Correct. So in terms of item number 5, 6, why is 5, 6, and 7? 7.
And they're very specific, my lord, about the works, my lord. My lord, while your lordship is on that work order, my lord, kindly, my lord, if your lordship keeps note, my lord, of clause 3, my lord, of the work order. And this is the price basis, if your lordship finds. This is one of my, excuse me, main submissions, my lord. Kindly considers 3C, my lord. Payment will be made on actual quantity of job executed and duly certified by trial resident engineer or site supervision agency. So the first onus is on my learned friends to show that they had done the work, got it certified, and then, my lord, they'll get the payment.
5.
Even in the terms of payment, my lord, if your lordship sees 5, my lord,
It will be ratified by the resident engineer or site supervision. 5B.
5B, if your lordship kindly sees, 80% will be paid against RA bills duly certified by a resident engineer. So that was a precondition.
Yes.
Well, may I just go back to the award, my lord, if your lordship can?
Yes.
Page 16.
Page 16.
Page 16. Internal. .286. PDF.
Kindly come to page 16, and para 22. As I said, the first sentence, when I'll show that that was denied.
Yes.
The minutes of the meeting of 4th December 2000 was sent over by email of 30th December 2009. In terms of minutes of meeting dated 4th December, the claimant was required to give further details relating to the anti-termite work. However, it was admitted by the respondent that the anti-termite work has been done. The email dated 4th December 2009 has been replied to by the claimant through the letter dated 7 January 2010. In para 2 of the said letter is clarified that there has been that there had never been any denial of the fact that anti-termite work has been done by the claimant. In answer to questions number 136 to 145, the examination chief of the witness, the claimant has proved the bills relating to anti-termite work along with the relevant documents in exhibit as CA 1, 2, and 3. Such facts were not disproved during cross-examination. Well, I will refer to these documents, my lord. These documents one thing.
So it is
go to the documents.
the claim only for 5 lakhs something about.
Yes, now it's a very big figure.
Why it has reached a big figure?
Because it's been pending.
Your fault. You should have just given it to me.
I tried my level best. He's the third person. Before that, there were 2 others. Changes and changes. I've tried, my lord, but I could not get it through.
So what's your ground? Why he shouldn't be given?
Well, because, my lord, first of all, the amount has not been proved.
There's evidence to that effect that the work had been carried out. The only thing is that
the evidence, if you lordship kindly see,
it has probably not been certified. Not all.
One part.
Yes.
Even if it has not been certified, my lord, the documents which have been looked into, first of all, that the learned arbitrator does not go to any reasoning as to why this is the amount payable. But there is 2 differences. One is, yes, they have done the work. That is what they are saying. Then in that event, my lord, the next thing is the quantum.
You are Tata.
Yes. It is Tata. Yes. Well, they have taken a conscious decision on this one. I know, my lord. Generally, they don't do all these things. But here, for some reason, my lord, this has been challenged even for this amount. My lord, the settlement was tried twice or thrice, but ultimately they did not accept. We said we'll give this 5 lakhs to the original. We had said that we'll give them 10 lakhs, but they have said no, we want the entire interest and everything. This, I think, happened last year.
Last year?
Last year we had offered.
Mr. Banerjee.
Mr. Banerjee.
I was trying to
use your good officers to.
I was trying to. May I just have a word with my lord? Difference is 5 minutes between. I will try.
Try to bridge that difference. Try to finish it off.
And I will also give a ballpark figure. Let me also see on my side. Let me see on their side. Let me come back out next week.
Need not waste my lord's time.
Yes, definitely. I also believed in it. but for some reason his predecessor did not accept it.
That's why I'm here.
So, my lord, but I'm sure he'll be a better negotiator.
Yeah, absolutely, Mr. I have full faith in him. So
I'll try.
let
কথা বলে দেখুন একবার কথা বলুন। দাদা 12
আমি তো আগে তো বললাম
12 বলছে 12 13 একটা 15 বলছেন 12 13 না আলটিমেটলি এর থেকে 37 ইঞ্চি দেখবেন যা পেলাম তার থেকে বেশি খরচা হয়ে গেল।
at the request of the parties, let this matter be listed. I'll give some time. 24th of February.
Great.
February. 24th of February. And keep it up in the list so that we can get lost.
But could it be the first week of March? My advocates are not there.
First week of March. 9th of March. 9th of March. But
great.
Try to finish.
Yes.
This doesn't require.
But my advocates were saying the week earlier.
I don't want to go through all that.
That's why I'm trying to keep it as concise as possible. But obviously, I had proposed.
You all have that advantage, for your fees. You tell me, is it expected? All of you are charging so much, and you make us work.
But I am saying this. The proposal came from my side, Malad. I do appreciate. That's why, Malad, I'm trying to narrow it down so much, Malad. Malad, we also appreciate, Malad, and it's obviously, Malad, a case of judicial time is also, Malad, not to be wasted. Let me try, Malad. I think
Let's
with him on the other side, I think I can negotiate. Let's see.
Absolutely.
How about finish it?
Try to my level.
unlucky 30 or lucky 30?
Grateful.
May it please your lordship. I am appearing on behalf of the petitioner, and this is my application for setting aside Milord under section 34.
First time?
This has come up for the second time. The last time it was only for a few minutes at around 9:24.
It's first time.
At around 3:24, the matter was taken.
In that sense.
Award is of which year?
Yes, Milord, the award is of 2018, 21st of December 2018, and your lordship will find it, Milord, after page 299 of volume 3. Before I invite your lordship to the award, Milord, I essentially, Milord, plan to only take your lordship through the award because I am fully conscious of the limitations of section 34. Milord, my main grievance, and I was the respondent in the arbitral proceedings, Milord, is that certain claims have been allowed which arise out of a works contract. I am, Milord, representing the West Bengal Housing Board, and Milord, the petitioner is Abhishek Constructions.
Right.
Now, Milord, certain claims have been allowed which are based on lump sum basis. Claims were of the nature of loss and damage suffered, compensation awarded for that. But the learned arbitrator, who admittedly wasn't a man having a legal degree, but was from, Milord, an engineering background, he proceeded to award certain claims on a lump sum basis, and that is exactly, Milord, the phrase he uses, something which is reasonable for him. And that is the basis of awarding these sums of money. So, Milord, in my first limb of argument before your lordship would be that this is not in consonance with the settled provisions of section 73 and the principles of section 73 of the Contract Act. Because the question of liquidated damages is not appearing here. Even for liquidated damages, the Supreme Court, Milord, in Fateh Chand, quite some time back, has made it very clear that one has to prove, or at least near about proof. And from then, the adjudicator, be the court or the arbitrator, can then take a cue. But that is absent. The second, Milord, limb is that the arbitrator comes to a finding that there has been, Milord, essentially your lordship, Milord, knows that in works contract, the main issue is work has not been completed within a specific period of time. This is always the main issue. Now person A is blaming person B is blaming person A. The same issue is also here. But the learned arbitrator, my lord, he comes to a finding that both are to be blamed. And that is the recorded finding. But at the time of appreciation of the claim, he says that both are to be blamed, but I award this much percentage. Respondent should be blamed for this much percentage, claimant should be blamed for this much percentage. And then he apportions the claim likewise. If both are to be blamed, in my most humble submission, then that integration of percentage, 70% to be blamed for respondent and 30% to be blamed for the claimant, perhaps doesn't bear out of the evidence which was before the learned arbitrator. And the third, and when he holds that both are to be blamed, then of course, the question of awarding damages doesn't arise because it is conflicting. If one has to be in breach for section 73 to trigger off, the only question over here is time, whether that was of essence or not. And if the arbitrator is accepting that time was of essence and both are to be blamed, or both are to be blamed, then, my lord, there cannot be any question for compensation. That's my humble submission. The last limb, my lord, would be that the terms of the contract had a fixed rate and there has been escalation allowed. So that is deholds the contract. Now, my lord, if lordship kindly takes up, my lord, the award, if I may take your lordship through the award. My lord, it begins from after page 299. It is not paginated, my lord. Second volume. My lord.
Second volume then, yeah. Second volume.
Lordship will find the award after page 299. Lord, it is not paginated, but the award itself has its own pagination.
Yes. Internal page?
My lord, internal page 6, your lordship kindly takes up, that is chapter 2, that deals with claimant's submission. Now, my lord, I am perhaps entitled to address, at least show your lordship what the claimant's submission is, without taking your lordship to the statement of claim, which I do not intend. The lordship will find, my lord, 2.01. The claimants submitted that they had offered their rate, keeping faith in the notice inviting tender, read with contract conditions as stated hereunder. Time allowed to complete the work is 2 months. Site of work was available and drawings and decisions were ready. Time of work was 2 months, which was deemed to be the essence of contract. On failure, the contractor would be liable to pay compensation to the respondents as per clause 2 of the contract. Respondents, we were the respondents before the arbitrator. Monthly on account payment would be made as far as possible within 10 days. 2.02. The claimant submitted that respondents protected themselves by a penal clause in the contract and believed that the respondents considered the work as urgent. Time of completion was reasonable and the respondents were ready with their reciprocal promise like supply of drawings, handing over of site, making of timely payments, etc. under the contract to enable the claimants to complete the work in the scheduled time. These are all submissions. The claimant submitted that the standard form of contract, as in the instant case, is a contract based between two unequal parties, government or government undertakings, the stronger one and a private company, the weaker party, as considered by the courts in India. The courts of India had taken judicial note of the fact that stronger side had clear advantage and weak has no other option but to submit to the dictates of the stronger party during the contract. They respectfully submitted that learned arbitrator may be pleased to interpret and or construe the contract in such a manner so that those clauses are not hit by the vice of unreasonableness. My lord, I only pause over here to indicate that this argument of, my lord, a standard form contract was not supplemented later on. Regarding the site of work, the respondent failed to make the workable site available within the entire stipulated period of 2 months, due to which no work was possible. Some portion of the site could be made available after 4 months from the commencement date, that is on 19/5/2010. The remaining portion of the site was available to the claimant in a piecemeal manner, time to time, and as a result, the claimants were all along prevented by the respondents to make progress in sight of their best efforts. This was their submission, a direct allegation on us. 2.50 Millard, this was with respect to drawings. I'm not reading out the entire thing. The last line says of paragraph 2.05, due to delay in making payment against work done. This was again an allegation against us. Now, Millard, with respect to 2.07, moreover, a group of local suppliers for sand, bricks, stone chips, etc. had done lot of disturbances by charging inflated rates and supplying less than the quantity shown in the challans forcibly. On a number of occasions, they threatened the workers, resulting stoppage of work. These incidents were frequent features at site. The respondents were aware of the situation and they were informed time to time of such happenings, but they maintained a studied silence and did not take any appropriate action to stop such law and order problem. Now, Millard, after that is a list of correspondence which they relied on. During the stipulated period of 2 months, no work could be executed due to reasons as stated above, and the work spilled over the extended period. In the extended period, the cost of labor, material, fuel, etc. were increased and the claimants suffered damage, loss due to added expense for execution of work due to failure of respondent. So, Millard, this is the fulcrum of their claim. Purely a claim for loss and damage and compensation. Now, Millard, 2.10 at page 8, the respondents granted time of extension one after another based on the prayers made by the claimants without imposition of any liquidated damages till the completion of the work. The work was completed on March 15, 2011 with satisfaction of respondents with a delay of 7 months and 26 days beyond the stipulated time of completion of 2 months. I only pause over here to say 2 months was the original period. They took 9 months and 26 days. So, which is an additional 7 months and 26 days. The claimants in the above circumstances were legally entitled to compensation for the respondents for the damage or loss suffered during the course of execution in the enlarged period. And then they state the reason: increased running on-site and off-site overheads, loss on idle labor and machinery, business or profit loss being detained longer without corresponding monetary benefit, increased cost of materials and labor, others, etc. According to the claimant, one purported final bill was prepared and paid by the respondents in mid-December 2011, which did not include all sums due to the claimants. By letter dated such and such, claimants preferred claims of outstanding dues and damages to the respondents with the intimation that they shall be compelled to invoke arbitration proceedings if payment is not made within 15 days, but the respondents refused to accept those claims by letters dated such and such, that thus disputes and differences had arisen. The claimants thereafter served notice upon the respondents for starting arbitration proceeding through their advocate by the letter of 28th March 2012. The claims preferred by the claimant in their SOC are briefly stated below. Here, Millard, your Lordship will find a synopsis of the claims which they had claimed at page 9.
Yes.
Now, if your Lordship kindly takes up page 10, is the legal are the judgments which they had relied on. And I will also be relying on 2 of the judgments which they had shown amongst this list. Now, Millard will come to chapter 3, which was the respondent submissions. Through the SOD, statement of defense, evidence and oral arguments, the respondents submitted their facts, issues, and counterclaims in defense to the submissions of the claimants as summarized below. Respondents submitted that theory of stronger party and weaker party and abuse of power in the contract, etc., as placed by the claimants are unnecessary and baseless, as no specific allegation against the respondent is made. Denying the allegation of the claimant, the respondent made it clear that land was in possession, drawing was ready, and technical hands were at site from the beginning. Several agencies were working side by side, and the claimants had to work there with mutual cooperation. The claimants failed to make appreciable progress in time, but to cover up their fault, they are putting allegations of non-availability of site, drawings, etc., etc., against the respondents. The claimants did not submit any work program to the respondents and haphazardly started the work, faced problems and delay was the obvious result of their own fault. But they tried to put blame on the respondents for the delay. Now 3.04. The claimant's allegation about respondents' delay on issuance of drawings, issue of departmental materials at the right time, etc., were baseless as those were not supported by any evidence. Whereas enough evidence and contract provisions are there in favor of the respondents, these allegations are fully denied. Regarding the local group of suppliers creating disturbances as stated by the claimants, the respondents submitted that many agencies were working in that area with the same environment. The claimants should have the common knowledge of the site or area before entering into the contract. Actually, the claimants' alleged sufferings were created by their own laborers and suppliers, and thereby the respondents deny such allegations, including lack of help and assistance from the respondents. There has been no violation of contract by the respondents as alleged by the claimants. According to the respondents, so long as the contract survives by the desire of the contractor and consent of the employer, all conditions, including its fixed rate, shall remain unchanged. Milord will kindly take a note of this because we have argued the point of fixed rate not getting changed. And the second point, Milord, that there was never any termination of the contract. Work was done satisfactorily. The claimant contractor argued, page 12, that they are entitled to compensation due to price hike on material, labor, fuel, etc., and other damages in the extended period. But the respondents deny such claims as all the terms and conditions, including the fixed rate, remain unchanged and valid in the extended period as also stated above. May I pause over here just to say, entire additional period was 7 months, 26 days. Allegation made by the claimant was that price has risen within only a period of 7 months, 26 days. But even the cost of fuel is not increasing within that time. And that allegation is not met by any evidence whatsoever. Now, Milord, I am skipping 3.07, but 3.07, Milord, the last line your Lordship will kindly consider at page 12.
Yes.
At page 12 of the award. Here we again make the submission that a fixed rate contract remain fixed rate even if it is extended 1,000 times. This was a specific submission. And Milord, at 3.08, we referred to in paragraph 26 of the SOC, claimants preferred their claims, which added together may exceed the whole contract value, but beyond the normal profit. And so we have said that your claim was not logical and your claim was exceeding the contractual value. Milord, what has to be kept in mind, even Milord, from the respondent's point of view, is that we were only concerned, work was given, it was a housing project which was coming up, and a certain portion of the work was given to Abhishek Construction, the claimant before the arbitrator. I am not going into the nitty-gritties because in a section 34, too much of appreciation of evidence is not entertained. So, Milord, in a skimmerish manner, if I may say this, Milord, certain works were given to the claimant for the development of the project, and the project had to be completed by deputing various other contractors. And they had completed the work satisfactorily. That is an admitted position. So as the housing board, we do not have any complaint with respect to completion of the work which they had done. The only duel between the parties was, Milord, respectfully, with respect to that 7 months, 26 days extra time, which was taken by them, and we had extended it because they were not asking for 17 months. And it was not an astronomical figure or astronomical demand. We also wanted the project to get completed because ultimately it is flats which will come up, which we will sell. And it has to have a time limit.
Yes.
Because, Milord, other parameters are also involved. they do complete the work. 7 months, 26 days is the extra period taken. But they come up before the arbitrator and say that within this period of time, the prices of the materials, the prices of labor, and the prices and cost of other paraphernal issues have risen. And risen to such an extent that my entire contract value being 1 crore 20 lakh odd, they had a claim much more than that. Which was, Millard, in my most logical conclusion, is, Millard, perverse. Because within 7 months period, your amount or your contract value cannot increase more than the original value. And most importantly, 1 crore 20 lakh was the entire contract value. That contract value was also reduced because we didn't want to burden them with what was already there. They couldn't complete the work within the stipulated period. Original contract time was only 2 months. So that was the limited scope of the work. But when we saw that they are unable to complete, we reduced the burden. And that was mutually executed through an addendum, which was effected. But when we got this claim, we added up and we saw that the claim is much more than our original contractual value, which was not, Millard, a very logical thing and should have been appreciated by the learned arbitrator as well. Now, Millard, we had a counterclaim that was, Millard, is reflected in page 12, Your Lordship has seen, on idle site expenditure of human input and idle on-site expenditure. This the learned arbitrator didn't allow. We also, Millard, had idle off-site overhead expenditure and other claims, which was not ultimately allowed by the arbitrator. Before Your Lordship, I would not be so audacious to ask for these claims, because as Your Lordship understands, when there is a claim, there is a propensity for a person, Millard, to also give a counterclaim to show certain bona fides, because a ground was taken by them that you have not imposed the liquidated damages, which means you are accepting that delay is only for West Bengal housing and at the instance of West Bengal housing alone, because you have not imposed liquidated damages onto me. So that, to counter that, Millard, perhaps the counterclaim was framed. But before Your Lordship, I will not be assailing it at this stage. Now, Your Lordship, kindly have a look at, Millard, page 13, from where the observations begin. And at page 13 itself, Your Lordship will find a summary, which is very essential because it, Millard, highlights the major list of dates. Contract price, Your Lordship will see, Millard, is 1 crore 19 lakh odd. Date of commencement was 19/5/2010. Stipulated time of completion was 2 months. Stipulated date of completion was 18/7/2010. Extension of time granted 4 times up to 15th March 2011 without liquidated damages. Actual date of completion is 15th March 2011. These are the established, undisputed and admitted records. Now, Millard, this portion which begins from paragraph 4A and has been referred as well in the subsequent portion of the award is very, very essential. Because here the arbitrator, Millard, comes to a conclusion. Who is to be blamed for delay? He says that both are to be blamed for delay, and then he apportions it, gives percentages onto both the parties. It is observed that the respondents were not ready with clear and unobstructed site when they issued notice inviting tender, though the allotted time to complete the work was as short as 2 months. Beyond the stipulated time for completion, there was also problem of land or work front, as is evident from several facts and records as stated below. The claimants time and again intimated respondent that full and clear site had been provided to them by letters dated such and such. Yes. But the respondents could not reply appropriately to those letters and as such admitted the issue of land problem. There were all other agencies working simultaneously at the same time, side by side, which also created space problem and other hurdles towards the progress as referred in the claimant's letters. The respondents admitted the same problem in their reply as they stated that they were trying to coordinate among the contractors to solve the problem. Due to such above reasons, the respondents granted extension of time, one after another, without imposition of any penal measure, as per contract by letters dated and the dates are given. The work was completed on 15th March 2011 with a delay of 7 months and 26 days beyond the stipulated time of completion. In my considered view, that is the last paragraph, Milord. In my considered view, the respondents are mainly responsible for the delay due to their failure to provide clear work fronts for the work from the beginning itself and during the course of execution. Now, Your Lordship will kindly have a look at the next paragraph, where the arbitrator, Milord, comes to a conclusion that it is also the claimant who was delayed, who had delayed the work. Though the respondents were found mainly responsible for the delay in providing land or work front for the work on site, on one hand, on the other hand, the claimants were also found responsible for slow progress and delay due to various reasons of their own. And as complained by the respondents, even if when work fronts were available to whatever extent. The details of a few such happenings are below. Milord, Your Lordship will kindly excuse me from taking Your Lordship through these 1 to 4 because I will ultimately not take Your Lordship through the letters in a section 34. Kindly, Milord, have a look at point number Roman 5. In defense of slow progress, Milord has it, that's the last paragraph. Yes. In defense of slow progress, the claimants on several occasions tried to establish law and order problem created by local supplier, miscreants nowadays known as syndicate, but adequate records about taking up the matter with the administration or police were not produced. The matter was informed to the respondents in a number of letters, but respondents had chosen to avoid the syndicate problem faced by the claimants for their own convenience. From the above facts, records, and circumstances, I am convinced that the claimants were also responsible for some considerable delay due to their problems as stated above. So, Your Lordship will find from observations made in 4A and 4B that the arbitrator goes through the letters and takes into consideration the submissions of the parties and comes to a finding that both are to be held responsible. I cannot, Milord, at this stage show Your Lordship any document from where I perhaps would be able to show that no, he has come to a conclusion which is red and actually it was green. So I will not even endeavor that. I accept what has Milord been observed by the learned arbitrator, that both are to be delayed. But what Milord is perhaps the arbitrator has transgressed his powers is in 4C, where he himself apportions the delay. And that is a method which neither of the parties had suggested or made any submission or produced any evidence. 4C, apportionment of delay. It is observed that respondents could not hand over a workable possession of site to the claimants during the stipulated time of completion of 2 months. First RA bill for a meager amount was paid by the respondents after 1 month from the stipulated date of completion. Even thereafter, total clear work front was not available due to presence of other working contractors at the same location, though the whole land of housing estate was under possession of the respondents' department. Land was available to the claimant only in bits and pieces. The work was completed on 15th March 2011 as recorded in the measurement books. As per records, the total working period was from 19.5. Here, Milord, he comes to the conclusion, which is important. Total working period was from 19th May 2010 to 15th March 2011, which is calculated as 9 months and 26 days, out of which delayed period was 7 months and 26 days beyond the stipulated time of completion of 2 months. Considering the facts and circumstances in this context, I am convinced that both the respondents as well as claimants were responsible for the delay as stated in paragraph 4A and 4B. based on facts and records, apportionment of delay between the parties as considered or assessed fair and reasonable by me is presented below. Milord, the expression fair and reasonable has, Milord, subsequently been deprecated by the Honorable Supreme Court, saying that this cannot be a parameteria for any kind of assessment. And if it is damages, then one has to be precise. Total working period, Milord, he holds it correctly, 9 months, 26 days. Stipulated time of completion, 2 months. Delay beyond stipulated period of completion, 7 months, 26 days. Respondent responsible, here, Milord, is something which is coming as an assumption from the beginning of page 17. Respondents responsible for gross delay. EOT granted without LD due to land problem, 7 months and 26 days. Claimant responsible for their own delay as assessed, regard reasonably by me from facts and records, 3 months, 26 days. Either it could be reasonably assessed by the arbitrator or coming from facts and circumstances, that is evidence before the arbitrator. It could not have been both. But what the learned arbitrator, Milord, has done, he has come to a reasonable figure of 3 months, 26 days to be the delay for the claimant. Respondents responsible for net delay, point D minus point E is 4 months. So essentially, Milord, it is just a difference of 4 days. If your lordship, or 26 days, if your lordship looks at it in that way, there is no dispute regarding the gross delay and date of actual completion. The respondents were responsible for net delay of 4 months. Here, Milord, I join issue. However, I must be very candid that when the arbitrator has come to a conclusion that delay has been for both the sides, then, Milord, that issue gets negated. If delay is for both the sides, there is no question of appreciating or no requirement of appreciating a claim for compensation for loss and damage suffered due to contractual breach. Because delay is the only reason or only allegation perpetrating to several other factors. If the arbitrator says that delay is for both, then there is no question of going into any further assessment of loss to ultimately award compensation. But the arbitrator here, Milord, bifurcates or apportions it. And there is not a speck of formula which your lordship will find. Well, this has to be some formula over here. Otherwise, this figure could not have been before your lordship. Or some assessment of some particular documents where parties have agreed to this formula. And your lordship is completely aware, Milord, that if parties agree to any kind of procedure for assessment of loss and damage, then at the time of appreciation of a grievance, that formula may be applied. But here parties never agreed to any formula for any loss or damage which either of the party would have suffered. So naturally, Milord, the assessment of or appropriation of loss of 4 months on the part of the respondent, my most respectful submission, Milord, is without any basis, which we may call as baseless and hence perverse under section 34. Now, Milord, finding number 1, responsibility of delay. The respondents were responsible for a net delay of 4 months. Compensation in favor of claimant is to be ascertained according to the above delay. The next limb, Milord, is on the assessment of compensation. Milord, this is another new limb which I would be venturing into. If your lordship wants, I may continue, or in the presence, it would have been better in the presence of Mr. Mitra, Milord. I am ready with the judgments as well. If your lordship wants, I can supply copies to Mr. Mitra.
Come, my lord.
He'll come. He'll come.
Then I'll continue. But I must be very candid. From now onwards, Milord, we find reference of a particular document which we had, Milord, through a notice asked to be produced by the claimant, which they have said, and they have produced us the document, which is the statement of claim. I will not be referring to this, but I wanted this to be before your lordship because the arbitrator has referred to this particular set of documents. If it comes as from the reading of the award, Milord, I will then indicate to your lordship. I had written to them that kindly produce this because you had produced it before the tribunal. We do not have a copy of it, otherwise I would have produced it myself. But they have, my lord, given us the statement of claim, which is already there before your lordship. It is actually the annexures to the statement of claim, which perhaps the arbitrator has referred to, which is not before your lordship. But anyways, it's a section 34. It makes my job easier.
Yes.
My lord, first is the 4D compensation. As mentioned in finding number 1, respondents were responsible for delay of 4 months, as stated above, for which claimants are entitled to compensation according to section 73 of the Contract Act from the respondent. Kindly marks this, my lord. The learned arbitrator, although, my lord, he was a retired engineer, chief and ex officio secretary, my lord, not having perhaps a legal background, but he was completely conscious, or he was made conscious of the provisions of section 73 of the Indian Contract Act. Now, my lord, point number 2. Delay in execution has an impact on the cost due to additional expenses incurred in the enlarged period. Damages has been suffered by the claimant as established from facts and circumstances of the contract. I only stop over here to explain before your lordship, my lord, that facts and circumstances of a contract does not explain delay, respectfully. Contract says contract terms. It is the evidence appended after execution or complained of which leads to the facts and circumstances on allegation of loss or damage. So only the contractual terms and the pleadings will not be sufficient for a party to establish compensation under section 73, because it will, my lord, your lordship will appreciate, section 73, my lord, has 3 parameters. If your lordship, my lord, kindly allows me to say this, because then, my lord, it will be easier for us perhaps. First, there has to be a breach. Second, my lord, because of the breach, there has to be loss and damage arising in natural or usual course of business. And lastly, my lord, that loss and damage cannot be remote. And the person who is affected by the breach has to show before the adjudicator that he has attempted to mitigate the loss. Now, my lord, of course, mitigation of loss is only a legal principle which ultimately helps to balance the claim. Over here, there may be a breach complained of, and the arbitrator says that both are to be blamed for the delay caused. So he says there has been breach from both ends. That is the admitted position. There is no section 34 filed by Abhishek Construction. Your lordship will appreciate, even if there is a observation which, my lord, is, or any observation of an award which is affecting the claimant, they could have filed a section 34, but they accept what is there, what is the finding. So they accept the finding that there has been delay for 3 months, 26 days on their part. So there has been contractual breach on their part. It's an accepted position. So first, there has been breach by both the parties. Second, my lord, there has been loss and damage complained of, which are, my lord, the several heads of claim. One of the heads of claim was for work done unpaid, which ultimately, my lord, the arbitrator holds by saying you have not produced any evidence. So this should not be paid. So arbitrator is fully aware of the consequence of laying evidence. So, my lord, loss and damage suffered, but there is no evidence before the arbitrator. And these are, my lord, claims in the nature of idle labor, additional expenses for laying down equipments, and etc., as are the usual claims. But because there is no evidence, arbitrator, my lord, could not have come to any precise finding regarding a particular sum, which has been allowed as a compensation. And lastly, my lord, even if I ignore, the arbitrator never questioned what is the step taken by the claimant to mitigate such a loss. If they are facing a difficulty, 2 months is the time. At the very inception, after 2 months, first day or second day, they could have issued a letter invoking arbitration saying, I cannot proceed. And even ask for the entire contractual value by not performing anything, because that is permissible under law and permissible under section 74 itself. 73 itself. So here, my lord, if I may proceed now, the compensation for loss and damage suffered by the claimants, which naturally arise in the usual course of things and have a direct bearing on the work, are to be considered. Here, my lord, the arbitrator quotes basically section 73, and then, my lord, he has gone on to appreciate certain documents. At page 18, my lord, there is also further observation, my lord. Lordship will kindly take up the middle portion. It is observed, your Lordship has it, my lord, at page 18. It is observed by the arbitral tribunal that by the above argument and action, the respondents voluntarily shown less obligation towards the contract provision rather than extending generosity to the claimant for their own convenience. Such time-to-time grant of extension cannot defeat the right of the claimants to claim damages due to delay attributed to the employer. Furthermore, the respondents voluntarily surrendered their own right to claim by their own admission of not taking any penal measure. Extension of time has usually an impact on the cost. So here, my lord, the observation basically indicates that if there is extension of time, the cost, that's the last line of the paragraph in the middle, extension of time has usually an impact on the cost. This is, my lord, also indicative of the fact that this has an cost implication on the contractor as well. That is me. Now, my lord, finding number 2, compensation. The claimants are entitled to get compensation from the respondents for damages suffered by them due to delay or breach of 4 months attributed to the respondents according to section 73 of the Indian Contract Act as established from facts and circumstances. The respondents are not entitled to any compensation whatsoever. So we are not entitled to any compensation. It is only the claimant which is being held. And most important, no, then is appreciation of certain documents. And then, finding number 3, extension of time. 4 numbers of EOTs were granted by the respondents without imposing any liquidated damages against the claimant, which is on record and without any dispute. Here, now, 4F. 4F, precisely is an extract from the observation made by the Honorable Supreme Court by referring to Hudson's Building and Engineering Contract, which is the 10th edition, chapter number 9, 596 to 598. I will certainly not take your lordship through the entirety of it. Mr. Mitro Lanet, senior advocate, may. But what in essence indicative, is kindly have a look at page 22. If your lordship comes to page 22, the arbitrator has given a synopsis.
Yes.
But with deepest respect, principles of section 73 cannot be overlooked or replaced by an extract from the Hudson's book. Over here, it is stated at page 22, in the instant case, claimants are entitled to compensation for delay damages. Delay damages, is a phrase used in that paragraph. Due to employer's respondents' breach of partial prevention as established from facts and circumstances of the case, according to the reference or guidance as cited in the paragraph or chapter of the reference book, as mentioned above, it is an established principle and legal position which is valid in the present dispute or matter. Similarly, under section 73 of the Indian Contract Act, claimants are entitled to compensation due to breach and delay by the respondents. Till now, your lordship has not found even one document where the arbitrator has held that, yes, for additional employment of labor or extended period for that additional 7 days, for each labor you have paid rupees 120 and rupees 80. So your daily cost is 200. There has been delay for the respondent and hence you are to be awarded this amount. But even that would not be sufficient because he has to show that he has paid that 200 rupees for each cost incurred. And that is perhaps, the correct appreciation of section 73. Now, 4G, points raised by the respondent. This is very important, because now I only have this. I will not take your lordship to the statement of defense or anything else, but only the award to show what I had argued precisely. What I mean, West Bengal Housing Board had argued. The respondents during their argument raised three important questions against the claimants. Reply was given by the claimant during their reply argument. Arbitral tribunal's decision on such question and reply are presented as below. A1. Respondent questioned the validity of Sri Abhishek Mistry. One of the partners, Lordship will kindly ignore this, Millard. I am not assailing this point. Kindly come to Millard. Point number 3. Ignore the this Millard, it is a partnership firm. The claimant is a partnership firm. We had contended that the partner who is representing you is not the majority partner. So you are not empowered. That I have been able to Millard tell them, please don't assail this point before you. Millard will kindly come to page 24, where Millard, chapter number 5 begins, the award. It begins with the title award. The claimants preferred their claims in pages 16 to 21, paragraph 23 to 27 of the SOC, along with the summary thereof and quantification of the claims have been presented in a separate document. The respondents denied the claims of the claimants in page 58 to 63 of the SOD and presented their counterclaims in page 63 to 67 of the SOD. So these are, Millard, I have verified it. These are correct observations as far as the page numbers are concerned. And even as far as reference, Millard, to the other documents are concerned, I have checked them that is correct. I have examined the pleadings, exhibits and arguments put forward by the parties, considered the facts, issues and legal aspects and have come to the conclusion and making the following award keeping in view of my observations and findings.
Claims we'll do on the next date.
As your Lordship pleases, Millard. Yes, because from here, Millard, I absolutely go to the claims
and the judgment.
Yes,
then we'll keep it further. We'll keep it tomorrow or when do you want?
As your Lordship pleases, Millard.
Tomorrow?
Yes.
Mr. Banerjee?
Next week.
Heard.
Millard, would your Lordship want to keep it next week in that case?
No, tomorrow?
Yes, then tomorrow. But we have made a list, if your Lordship, about the judgments. We can hand it up.
Tomorrow we'll take.
May I hand it up to my lunch secretary?
Heard, Mr. Banerjee. Listed for further hearing. Tomorrow.
I'm deeply obliged.
Let's maintain the continuity so that.
Mine.
Otherwise.